I wore some of it, shirts, you know, that don't feel bad.
Yeah.
I wore some of the other ones, you know, they're like generic.
Have you ever wanted a holster?
But that's supposed to be leather on the side, and really, it'd be a good place to put a cell phone in the other side too.
All my bags.
I might order one of them, I got.
I wore every kind of holster, I think.
But
I wore the shoulder holsters.
see, I wear on my ankle already, you know, and
You know, when I went in narcotics, they, you know, we're carrying secure and
And then, whenever she got all that out, she.
That's just the thing. I don't believe that.
And then, I believe her the Lord again. Still does.
Yeah, all that.
So that's what. Well, it'll be. So there's.
He is. Yeah, he had the.
Yeah.
I was.
Yeah. I'm back. But how long is it?
Where you're around.
See what?
Oh, thank you for coming in on short notice. Will you raise your right hand, please? Solemnly swear or affirm that you conduct your duties as a member of the circuit board. That you fairly consider all matters involved before you. That you follow all the Commonwealth of Kentucky and protect the Constitution of the United States of America, Commonwealth of Kentucky. So, yeah, thank you very much. You go with the clerk.
Thank you, Judge.
I guess it's time to start. Calls to order. No, just say second to order.
Cumberland Circuit Court is now in order.
Thank you very much. Yeah. We'll start on the criminal docket. If I haven't publicly done so yet, I'd like to thank the Burkesville Christian Church for serenading us on the hour. I think it's a good addition to our city all the time. It's very uplifting. We'll get a good
Not scheduled.
exposure to the sounds here. We'll do with the transported prisoners first. Commonwealth of Kentucky versus Timothy Alexander. Point at this point, Nixon. Commonwealth of Kentucky versus Timothy Alexander, 19 CR 0042 and 23 CR 0039. Are you Timothy Alexander? You born in 1982. Last four digits, social security number 5227. You're here on a pretrial diversion revocation and also on a pretrial conference. What does the Commonwealth have to say?
I believe we need a trial date.
You want to come up to the podium while we get you on the record?
Yeah, I believe we need trial dates, Ron.
What's the charge?
It's assault second. Maybe, yes. And then you got the diversion revocation and the assault is the basis of the diversion revocation.
Go back there and have them turn back. Plug in and get my calendars out. Go ahead.
Yeah, the underlying case, the new case is the basis of the diversion revocation, so we'll need a trial date.
Okay. My electronic calendar is out, so I have to plug it in here. I wasn't aware of it. It's out of battery. It's step back and tell you, it's inside my briefcase. It's where the cord is. I think unless you mess it.
Well, that's longer than normal. That's what it is. Yeah. It's one of the few places I know rings bells, right?
It's inside, it's very close. Just as well as your Jesus.
Where you plug it in. Juice it up here. I went over to buy a new phone yesterday. It cost more than my first car.
Yeah, that's true.
There we go. How long out do you need this, Mr. Stockton?
I doubt we'll have any medical personnel from Nashville. I'll probably just introduce the medical records and the pictures. So I'd say that's the way we'll go on this. I doubt I'll be able to get a Tennessee doctor to come up on this. I can try, but if you want to set it sometime February or March or a little after, then I can try to get one. I'll know whether I have one available. I know Mr. Alexander's been in jail for a while, so.
Well, let's look at. You've got, on March the 4th and 5th, you got Commonwealth versus Key, that would probably go. And on the 11th and 12th, you got in Monroe County, you got Commonwealth versus Russell. What is that about?
That's an assault case where this lady was shot by Mr. Russell allegedly.
That'll probably go too. then.
Yes. And then I think we got 1/12, 13th, the Padilla case.
Yeah, what now?
Jesus Padilla, that was reset for the 12th, 13th. It was
Of
actually,
March?
yes.
Don't have it all.
February.
Oh, February. I got it wrong month. Yeah, it's the 12th, 13th February.
Isn't this a one-day trial, you think?
I don't think so.
What about March the 18th?
That's fine with me.
That'll look for me, Your Honor. Could we address this bond, Your Honor?
We can in a minute.
Okay.
Sorry.
And we've set the Cumberland motion day that month on March 9th.
That's right.
So if we have to, we can go over to that afternoon and finish the trial. Mr. Stockton, we have set the rule date for March in Cumberland County the next day. So if we have to go over, if we don't finish the first day, we can go over and finish starting the afternoon of the 19th. See what I'm saying?
Yes, that's fine.
Finish the rule there.
That's fine.
Okay, now, I hate to make these bond decisions just out of the blue. Have you filed a motion?
We've had a hearing, Your Honor. We had a hearing in
Yeah.
October.
I know, I didn't grant that though.
Well, we never had a decision.
You do now.
Okay. All right, Your Honor. He's been in custody for 255
Do you want to
days.
file another motion or you want to talk about what's the story?
The Commonwealth actually signed an agreed order at one point, Your Honor, but.
Yeah, he was going to be out on home incarceration. But that was when we were trying to get the medical records because there was a delay in getting those. So
How about an ankle bracelet?
that'd be fine with Conway.
Mr. Alexander?
No contact with Mr. Howard.
You have a violent past. Yeah, here, as far as this allegation are concerned. I don't know whether you did this or whether you didn't. What kind of criminal record does he have?
He's on probation for the possession and a DUI. And then he had an assault for conviction 2019. Speeding ticket 07.
Yeah. Well, I'm gonna let you, where are you gonna live if you get out?
My mother,
Where is that?
325 Hill Street.
Okay, well, I want you to stay there. I'll put an ankle bracelet on you.
Yes, sir.
And you can go to, have you been working publicly? Have you had a job?
No, I was working with, Frank Gasker.
Well, can you get a job there?
Yes, sir.
Well, you can go to work, church, or the doctor, okay, and stay at home. And you make arrangements with Junior Smith. Is he still doing that? Junior Smith? And your court date's on the 18th. Yeah, you need another pretrial?
No, Your Honor, not this
Okay.
time.
Okay.
Thank you, Your Honor.
Yeah. Thomas Bradshaw. Let me see this motion. I haven't seen. Sheriff, you okay with that?
You. Decision. Of 14, 40 years. Mr. Bradshaw or Alex either. Here's Mr. Bradshaw, I apologize. I got your number.
Yeah. Mr. Poindexter. Mr. Poindexter, I had made a decision, a bond decision on that was served on,
Okay, oh, we never got a copy of it, bro.
but it says you did, it said it was served on you by fax.
Oh,
Commonwealth versus. And this is Timothy Alexander here. Commonwealth Kentucky versus Bradshaw.
Yes, Your Honor, that's our motion.
It's got the medical proof.
Judge, this actually relates to the Senate, the imposition of sentence and the judgment as a whole. We're actually seeking to vacate the judgment, Your Honor, to remind the court. This was initially went to jury trial. Jury came back with a verdict, not guilty on DUI and possession of methamphetamine, guilty on careless driving and possession of a controlled substance. Particularly a prescription medicine that Mr. Bradshaw had a valid prescription for. Judge, we have two charges that have yet to be disposed of. Mr. Bradshaw had agreed to enter a guilty plea on one of the counts.
What was that?
That was prescription not in proper container
Yeah.
and license not in possession. Which that is yet to be disposed of as well, Judge. So I think we have that pending. Judge, with regards to the crux of our motion, Mr. Bradshaw was essentially convicted again of having his own prescription, a valid prescription. Judge, I noted in my motion with the jury instructions, with the jury having to decide if an individual lawfully possessed their own prescription. Judge, again, that is a defense, but that's improper burden shifting. And Judge, with that, the statute actually talks about a prescription from a licensed practitioner. So valid prescription licensed practitioner. It doesn't contemplate that an individual has to lawfully possess, which is what the jury was charged and deliberated on. Judge Mr. Bradshaw has, in Adair County, related to this case, was probation was revoked there. And understanding the uniqueness of this case, the court in Adair County sanctioned him as one of, pending this court's approval and parole approval, sanctioned into rehabilitation. I think it's evident from the trial and Mr. Bradshaw's own admissions, he has drug problems, wanting to seek care for that. And having a 12-month sentence for possessing, again, his own prescription is not helping his drug problem.
What do you have to say?
Well, we had to try this case because Mr. Bradshaw maintained his innocence and didn't say that he needed rehab or he didn't have a drug problem. It was a jury trial or nothing. We had a jury trial. I didn't agree with all the jury verdicts in this case. But if you take Mr. Pennington's argument at face value, that means you can have a oxycodone stuck up in your sun visor and have a valid prescription for it. And that way you can always meddle in this stuff and have improper medicine. You don't know if it came from the doctor, if he bought it off the street or what. And I think that was the conclusion this jury reached when he had that Suboxone in his little pill bottle with nothing on it. So he could have easily complied with the law if he wanted to. I just think that the jury spoke on this. I don't agree with all their verdict, but they spoke and we need to abide by it.
Again, Judge, the arguments that counsel made in summation was to the effect, having that one pill in a bottle constitutes the possession of a controlled substance. Well, Judge, that constitutes prescription not in proper containment, which is a charge that Mr. Bradshaw was wanting and in fact agreed to plead guilty to avoid the jury confusion. Speaking to the treatment and the aspect, Judge, Mr. Bradshaw did ask for help. In fact, we wanted drug court in this case. But for the Adair County Commonwealth attorney, Mr. Bradshaw being drug court there, we wouldn't be standing here.
Well, I watched the jury. I thought the jury verdicts, I accept them, were astounding. I cannot believe they did not find him guilty of possession of methamphetamine. And I cannot believe that they found him not guilty of driving under the influence, but that's their prerogative to do that. I think they gave him the 12 months because he's a proven liar. I've never seen anybody get on the stand and lie any more than your client did. I have no sympathy for him. He's lucky that he just got 12 months. I think the instructions were correct. And I think he attempted to perpetuate a fraud on the judicial system. That's my opinion after having watched him. I mean, and as far as those medical records you tried to get in, it's not Mr. Bradshaw's problem that they didn't get in. It's your problem because you didn't properly prepare the medical records and get them certified, and you didn't have anybody to get them in. They weren't admissible until your client made some allegations and the Commonwealth brought them in. They ultimately got in, and you could use them in any way you did, but those medical records didn't help your client because they showed that the day after he alleged that he didn't drink alcohol, he didn't do these other things, that all those things were in his blood system. So I think the jury instructions were correct, and I think that the sentence is correct. Now, have they revoked him up in Adair County?
No, Your Honor, they actually sanctioned him, and Judge, I think.
Well, that's their prerogative. As far as down here, the Court of Appeals can overturn this conviction if they want to, but I think it's a good conviction.
Judge,
I'm finished with this case. Okay. Do you have anything other than what I've addressed?
yes, Judge.
Okay, go ahead then.
It's my understanding in speaking with the parole officer in this case, that the charge is still listed as not possession of Suboxone. It's listed possession of a barbiturate, which I'm not a toxicologist or
I don't know
chemist.
what you're talking about as far, what do you mean the charge? The
Judge,
only thing I deal with is verdicts.
I
I got
understand.
the verdict. What probation parole officer told you this?
Who is the officer?
Well, I mean, your client says a probation and parole. If you have something needs to correct, work it out with the Commonwealth. And if it's improperly listed, the conviction stands for itself. It's a judgment that was entered. You know, I mean, I don't understand what the charge, I guess. The problem is that it was a misdemeanor and there wasn't any pre-sentence investigation report because it was a misdemeanor. Usually this would be corrected on a pre-sentence investigation report.
I don't even know what needs to be corrected. The indictment was correct, the jury instructions
I don't know
were
what
correct,
he's
so I
talking
don't know
about.
what's incorrect.
I don't know either.
Yeah.
But if you can find out something yourself by talking to probation parole officer and get a hold of the Commonwealth, if there's something wrong, we'll fix it, okay?
Well, Judge, there are still 2 remaining charges.
Commonwealth moves to dismiss.
They're dismissed with prejudice. Okay, thank you very much. Joshua Duval. Commonwealth versus Joshua Duval, 23 CR 0030. Are you Joshua Duval?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last 4 digits of social security number 4641.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at this pre-sentence investigation report done by probation and parole?
Judge, I have not received a copy of Mr. Duval's.
Well, you know, you knew he was here for sentencing. You think there's not a pre-sentence investigation? Did you inquire about it?
Judge, that's why I did a transport order to have him.
Barbara Johnson.
Good morning, Your Honor. Jason Page to Barbara
Commonwealth of
Johnson.
Kentucky, good morning. Commonwealth of Kentucky versus Barbara Johnson, 21 CR 0024. Are you Barbara Johnson?
Yes,
Were you
sir.
born in 1990?
Yes, sir.
Last 4 digits, your social security number is 7842.
Yes, sir.
You're here represented by counsel on a probation revocation. What does the Commonwealth have to say?
You know, Mr. Johnson had a 3-year sentence on possession of a controlled substance. And she was scheduled to be supervised, looks like on February of this year. And then when I don't think they were able to supervise her during that time. And she's had some multiple drug tests, fentanyl, methamphetamine, benzos, marijuana. And a new misdemeanor arrest driving on DUI suspended license.
You want to stipulate or you want to hear testimony? Either way is fine.
Judge, this is a case where we asked Mr. Stockton to consider. Judge Grice had ordered drug court. Probation and parole said that they didn't want her to be just supervised, but didn't have an issue with drug court. Is that something that we could agree to, Mr. Stockton?
I would agree, Your Honor, if she stipulates to the revocation, then if they can furnish me proof that Judge Grice is willing to take her in Warren County, we can shop her out.
We can do that, Judge, because he has committed her to drug court.
But all I know is right now is what Mr. told me.
Probation parole officer have to say about this.
Absolutely, Your Honor.
Pardon?
What do you want to know?
What's your experience with this lady?
She was probated and I transferred her to District 2 back in November of 22. Logan County. She was supervised by an officer, Gabriel Adkins, and he listed that she was lab confirmed positive for meth, marijuana, benzo, fentanyl. He sent her to rehab at Trilogy and she left after 9 days. They conducted a home visit on October 5th of 23 and they found her to be absconded. Then she was returned back to my caseload pending revocation. The day she got picked up, I sent Officer Amber Jones to the Warren County Jail to drug test her. and she was positive for meth, marijuana, and then she had the new misdemeanor charges. I did see some orders from Judge Grice, but as far as, I didn't read them because I was waiting to see what we were gonna do here.
You think it'd be better to revoke her or just to hold it in abeyance to see how she does down in the court?
Well, I think she's already a convicted felon.
Yeah.
And my thinking was,
Get behind them.
my thinking was if we revoked her and then she's shocked out, that's it. For her. She's used all of her time up. It's either this or nothing because she won't be eligible for shop again. if She gets revoked out there for it. But if you want to do it otherwise, that's fine with me.
She's been in about 45 days.
Well, I'm gonna revoke her probation and then you negotiate with find out from the Commonwealth Attorney's Office down there.
Yeah.
What the deal is. I might transfer the case down there.
Okay. that'd be fine.
To consolidate them for judicial economy. I'll take a look at it.
Yeah, this was just sprung on me this morning, so I need to confirm what's
Yeah,
going on.
I'm just gonna revoke her and we'll look into it. I'm not saying what I'm gonna do. I'm not adverse to her going to drug court, but she did.
Sir, Your Honor, thank you.
Wait, you finished? I'm not, I wasn't.
Oh, I thought you were
No,
done. I'm sorry.
no, I take a breath every once in a while. You know, you're looking right on the precipice of going to the penitentiary here. You haven't, you left that other, drug treatment program evidently. I don't know. We could take some sworn testimony. I don't have that now. So if it satisfies the Commonwealth to do that, I'm gonna revoke you right now and then, but she'll have to wait a period of time before I can shock probate her.
30 days.
Yeah, she'd still have to wait 30 days before I can shock probate her. If I do it that way, if I hold it in abeyance and they put her in drug court, she could go ahead and get out and get started on the drug court. You see what I'm saying?
So, well, if you want to hold it in abeyance, that's fine. I just need to get with,
Yeah, well, I'm gonna hold it in abeyance there, out of the possibility of her going ahead and getting in the drug court. Then if she doesn't do that, we can revoke her then and she can start her sentence. See what I'm saying?
Thank you.
Okay.
Thank you very much.
Yeah.
well, I'd like to, in lieu of revocation, then that she'd have to go into drug court if she doesn't apply with that.
Right. Have successfully complete their drug court. Okay, thank you. Jeffrey Carger. Jeffrey Carger.
Oh, okay.
And then Mark Martin is next. Mr. Carger, you want to come around? Commonwealth of Kentucky versus Jeffrey Carger. 23 CR 0086. Are you Jeffrey Carger?
Yes,
Were you
sir.
born in 1987?
Yes, sir.
Last four digits of social security number 1263.
Yes, sir.
You're here today for sentencing.
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir. I have.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to fleeing and evading the police first degree, he shall receive a sentence of 3.5 years. On a plea of guilty of wanton endangerment, he receives a sentence of 4 years. On a plea of operating a motor vehicle with under the influence, he shall pay a fine of $200. 2 sentences shall run consecutively for 7.5 years. The defendant shall have no contact with the victim. Now, you knew when you entered these pleas that if you got convicted of felonies in the future, that it can be enhanced. Is that correct?
Yes, sir.
And you knew when you entered the plea on operating a motor vehicle that it could be enhanced in the future.
Yes, sir.
Okay, I'm gonna waive the court costs considering the length of the sentence.
Thank you, Judge.
Thank you.
Mark Martin. Mark Martin, and then Kenneth McIntyre. Mark Martin?
Yeah.
He was not? Okay, well, I'll get to him in a second. Commonwealth versus Mark Martin, 22 CR 0056 and 23 CR 0036. Are you Mark Martin?
Yes, sir.
You born in 1974?
Yes, sir.
Last four digits, social security number 1961.
Yes, sir.
Okay, these are on motion for shock probation.
And Judge, it's my understanding in speaking with Officer Gardner that Mr. Martin will actually be parole eligible in January. And in lieu of that, I think it is in his best interest to withdraw the shock, or excuse me, not withdraw, but if Your Honor would just hold that in abeyance pending.
Well, you can file it. It won't be with prejudice if he withdraws them. I agree that it would be in his best interest to be paroled rather than shock probated.
Yes,
So
Judge.
you can just withdraw those two motions, and if he doesn't make parole, then you can file them again.
Certainly, Your Honor.
Okay, thank you. Kenneth McIntyre, I understand, was not transported. What,
I think he's in Pike County.
well, that was a
facility, not
motion
there.
for shock probation, so you can file it again.
Yes, Judge.
Robert Purdue. And then Brian Roberts. Commonwealth versus Robert Purdue, 22 CR 0. Yeah, get the hearing.
I'm sorry, Your Honor.
One of bailiffs, get the hearing device. Is that better?
Yes, sir.
Okay. Commonwealth Kentucky versus Robert Purdue, 22 CR 0046. Are you Robert Purdue?
Yes, no.
You born in 1963?
Yes, sir.
Last four digits, social security number 3514.
Yes, sir.
You're here for the purpose of sentencing. Have you had an opportunity to read the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced with Poindexter?
Don't think Your Honor would be the moment and.
Wait a second.
Okay.
Mr. Poindexter, is there any reason why this gentleman should not be sentenced today?
No, Your Honor, but there is a correction to the PSI.
Okay, what is that?
It shows that he's unemployed. He was actually approved November 2nd, fully favorable for social security disability.
Okay. Okay, you make notation of that. Now, was this where a pretrial diversion had been revoked?
That's correct.
Yeah. A pretrial diversion had been revoked. He shall receive a sentence of 3 years. And he still had the operating under the influence. What are the court costs in this case?
Sorry, Vegas.
I already paid the court costs. Okay, thank you very much.
Can we address probation, Your Honor?
You can address shock probation next time, but you can address probation if you want to.
Well, Your Honor, we would like to address probation.
Go ahead.
Okay, simply because when he received a fully favorable decision from Social Security, he will lose it if he's incarcerated for more than 30 days. And he'd been trying to get it for about 3 years. He's also had no criminal violations between.
How many days has he been in?
56.
This is the thing that bothers me about this case, Your Honor. I understand he wants to get out and draw his social security, but we had two separate hearings on Mr. Purdue. The first time he offered a drug test and he denied use. They had to lab. The second time they had a drug screen, he denied use. If he would just have cooperated with probation and parole, admitted he had a drug problem and got treatment, he wouldn't be in this position today. And now he comes to the court begging for mercy after he's been in all this trouble. I think the philosophy of a lot of these defendants is, I'm gonna lie to you, and lie to you until I get caught. And then when I get caught, I'm gonna come up with every excuse I can not to serve any time. And that's kind of where I'm at in this case.
How many days you say you would lose it incarcerated for how many days?
After 30 days from final sentencing, Your Honor.
He's been in how long?
56.
Hey, I'm going to delay final sentencing till the January rule day, and then I'm going to give him 29 days after that. That'll get him in about the time that he would be eligible for parole. You agree with that?
That's fine with me.
I understand that it probably does need the social security, so I'm going to delay sentencing until January the 11th. And then on that date, if it's okay with the Commonwealth, I sentence him to 1 day short of what it's gonna make him lose his social security on, maybe a week, just in case. That sound like a fair resolution, to you, Mr. Poindexter?
Solemn resolution.
Your Honor, when it's a guaranteed release, yes, sir.
Well, if I'm still alive, somebody else might think that's a good idea. But if I could guarantee that I'll be here and healthy, I surely would sign the order.
Would the court consider home incarceration? Just because he's also going through a divorce and they're doing property division and he's not
He's
there
got
for.
a pretty good deal up to this point. It's okay, so let's just stop it here and he can you can wait till he comes back on the 11th and I'll sentence him. If you got anything else to say then that's changed, it's not that long. The 11th is an early rule day for me.
Yes, sir.
It's not even like, okay.
Yes, sir.
What?
11.
Oh, this is a Clinton County case. And when is the rule day over there? Hold on just a second.
25th, Judge.
When?
25th.
Can you say it in Clinton if you want to?
No, it's a Cumberland County. What about Clinton County?
January 11th is not on the day. That's why.
Well, I had it right here. Just going by the list here. You look on- What is this list here? Last year's list?
Maybe so.
It's 25th, January the 25th. Yeah, if it's 25th, I might probate him that day. That's a couple more weeks after that.
And Your Honor, the PSI shows this is a Cumberland County case.
It is a Cumberland County case.
Oh, okay. I thought you said Clinton. I'm sorry.
Now, they said something about Clinton, and
Okay.
I have another Clinton County case on here, or a Monroe County case, and I thought it was Clinton. It's a Cumberland County case,
Okay, so January 25th.
January 25th. Okay, thanks.
Thank you, Your Honor.
Brian Roberts is a Monroe County case.
Your Honor, John Gardner appearing by Zoom for the Commonwealth.
Okay. Okay, Commonwealth versus Brian Roberts, 20 Monroe Circuit Court, meeting by agreement here in Cumberland County. Mr. Roberts, were you born in 1992?
Yes, Your Honor.
Last four digits, social security number 7584.
Yes, Your Honor.
You're here today for sentencing in 23 CR 0006 and probation revocation in 20 CR 0025. Now, I'm revoking the probation in 20 CR 0025 because I believe your plea agreement incorporated that. Is that correct, Mr. Cross?
I didn't quite understand the statement that in regard to the revocation, it was, he got a 90-day sanction on that he's already done.
I was just reading the plea agreement. I just saw at the bottom, the time concurrent with Monroe 20 CR 0025, and I saw that on here, so I just assumed. What does the Commonwealth have to say about this?
Mr. Gardner has the assault case. All I had was, we already heard the revocation. You gave a 90-day sanction.
Yeah. Mr. Garner, what's your understanding in this? He has 3 years?
That's correct, Your Honor, and we agreed to supervised probation for a period of 3 years as well on this case. I'd given Mr. Cross, a contingent offer about what happened in the revocation matter, and I think you gave him a sanction in the revocation matter, and so I agreed to probation in this matter.
Okay. There was $1,000 fine also.
That is included in the plea agreement, yes.
So, I sent you to 3 years, $1,000 fine. We don't know what the court costs are over there, do we?
No.
What are the court costs here? I mean, on felony, on any felony, what's court costs?
Around.
$215. It's, so he'll pay that. We have to pay it monthly.
Yes, $100 a month, Your Honor.
How about $70?
That's fine.
Okay.
Pay me that 30, okay, that works.
We pay you first, and this is a situation where you stab somebody, is that right?
Correct, Your Honor.
Well, don't we
That's correct.
stab anybody else? Next fist month, you'll be going up for a long time.
No, Your Honor.
All right, okay, 3 years probated, supervised, $70 a month, $1,000 fine, for $1,000 and $215 court cost. License for 3 years. Okay, and
And point of clarification, Your Honor, the 90-day sanction, he went in June 5th, so. June 15th, I'm sorry, 15th. So he, even though the paperwork didn't get through in drug court for some time, he has completed that. I think Mr. Stockton's.
okay, that's fine. I just looked at the order at the bottom. It's the only reason I brought it up. It cited 20 CR 0025 and 21 CR 0099. So that's fine. You'll meet, when should he meet with the probation and parole officer? Should he go to Glasgow, or who's gonna see him?
Meet with Chase, believe.
Yeah,
Wednesday. See him anyway. I'll see him anyway.
next Wednesday, this coming Wednesday?
I'll go see him tomorrow in Glasgow, Your Honor, as soon as they get up.
Okay, well,
Just taking care of
I'm
it.
gonna let you stay over there in jail tonight and then you'll be over there by 9 o'clock tomorrow, okay?
All right, so I get up tomorrow or today?
In the morning at about 8 o'clock.
All right.
Okay.
Thank you, Your Honor.
Yeah.
Thank you.
Nicholas Sexton.
I'm good. Thank you.
Nicholas Sexton. And then Dustin Sutherland. Tell him to have Dustin Sutherland on board. Commonwealth versus Nicholas Sexton, 23 CR 0019 and 23 CR 00106. He's gonna enter a plea today too, is that correct? That's what it's on here on 23 CR 00106. Pardon? Well, it's got a sentencing on here, and then it's got an arraignment on here on the
May
document.
it please the court? I
Yes.
think that's a mistake, Your Honor. He actually entered a plea on both of the cases. We did that by information, so it should be final sentencing on both cases. I think it was just mistakenly labeled an
It'll
arraignment.
be fine. Mr. Sexton, have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Any reason why this gentleman should not be sentenced?
No, Your Honor. One minor correction to the pre-sentence report.
Okay,
On the first page there, it references 23 CR 105. That should say 23 CR 106. I think the number was maybe hard to read. And then it's also referenced on about the fifth page under criminal history. It references 23 CR 105. That also should be the 23 CR 106. Otherwise, no other
catch
correction.
that over there? Okay. Want to plead guilty on 23 CR 00019, charge of unlawful transaction with a minor. 2 counts. Defendant shall receive 5 years on each to run concurrently for 5 years. upon plea of guilty, indictment number 20, information indictment number 22 CR 00105, a charge of sexual abuse second degree, received 12 months. Of course, the 5 years and 12 months you run concurrently for a total of 5 years. All evidence should be destroyed. Okay?
Yes, sir.
Okay. The court costs involved in this and how much?
155.
$155. I'll let him pay it $30 a month. First payment starts on 30 days after he's released. Okay.
Yes, sir.
Thank you very much.
Thank you.
Dustin Sutherland. Dustin Sutherland. Commonwealth versus Dustin Sutherland, excuse me. Commonwealth versus Dustin Sutherland, 21 CR 0035. Are you Dustin Sutherland?
Yes, Your
You're here on 21 CR 0035. You were born in 1982.
Yes,
Last 4 digits of your social security number 6346.
yes, Your Honor.
You're here on a motion for shock probation.
Yes, Your Honor.
Go ahead.
And Judge, if I could inquire from Officer Gardner or Mr. Sutherland's eligibility for parole.
Your Honor, he'll be pro eligible August of 2024.
So Judge, given that, we would like to proceed forward with shock.
Tell me something.
Excuse me.
Tell me something.
Uh,
Give me your your argument.
Me?
Your attorney
Yeah,
usually,
Ju-
why should he be shock probated?
Judge, Mr. Sutherland's problems were substance abuse in nature. Yes, he did have a hiccup at the beginning. Now that he's been in, he's had time to think about what he did, take accountability for his actions. He's actually agreed if the court would be inclined. Does tell me he could get stable employment, but he would also be willing to enter into either inpatient or outpatient rehabilitation to make sure that that problem is kept in check. Mark has agreed to accept him and could have a bed letter within 24 hours.
You know, I promise, I'm ready to start now. My wife's starting a second child and I'd like to be there.
What do you have to start?
The thing that concerns me about this case, Your Honor, he's got a 5-year sentence on trafficking. But the biggest concern is when he was on probation, he absconded from January through August of 2023. So he was gone 8 months out of pocket. So I don't want to be chasing him again.
You won't have to, I promise.
So that's my main.
How much time does he have left?
Well, he'd have a survey out. He's got 3 years and 4 days left, and he's not gonna meet the parole board till August of next year. So if, I don't know where he's gonna live, where he's gonna be employed, if he's gonna go into drug court. I need to know those things before I can agree.
Yeah, I'm gonna hold it in abeyance. You work with the Commonwealth, to see if there's something agreement with drug courts and other things like that. I'll consider it. You just can't abscond though. I'm a little, don't say anything else, okay? I'm a little reticent to give anybody that absconds 9 months shock probation. Take a look and see what's the last day you can apply for shock probation. How far into the 180 days is he?
Judge, I believe he was sentenced on October 26th, if memory serves me correct. So,
I've been in for 5 minutes. Oh, I don't know.
Well, take a
Judge, I'll
look,
check on that.
take a look at that, and we might go to the last day that he can file a situation and take a look at it there. If there's a drug court possibility, and you talk to Commonwealth about where he's gonna live and whether he's gonna have a job and all that sort of stuff. I just can't let people be absconding and out gomming around. And what do you do with somebody else that absconds and it's caught in 30 days, he's gone for 9 months? I don't know whether I'll even do it then or not, but I'll take a look at what you have to say.
Yes, Judge.
The next rule day, give me that. What was that?
January 25th.
James, did you find out what that was?
I think this was, premature list because we all haven't seen it.
January the 25th.
We'll make you a new.
Okay, thank you.
Yes, Judge. We'll talk to you.
Are you ready on Joshua Duval now?
Yes, Judge.
Give me Joshua Duval. No, I guess it's here, but
Okay.
Commonwealth Kentucky versus Joshua Duval. 23 CR 0080. Mr. Duval, you had an opportunity to look at the pre-sentence investigation report, Denver probation and parole.
Yes.
Is it substantially correct?
Yes.
Now, I believe I received a letter from you. Isn't that correct? Didn't you send me a letter? So I'll inform the defense counsel. I don't have the letter here. It was back there in a pile of Christmas cards and I saw it. He stated some contrition and in the letter, so I didn't want to receive a contact from someone and not put it on the record that I'd received some. Mr. Stockton, what's your position on this thing?
I'm asking to be sentenced. He looks like he would be a good candidate for drug court if he wants to file a motion for shot, but I think he should be sentenced.
Okay, I'm gonna go ahead and pose the sentence and I will consider, it looks like because the dates are involved here, he might very well be eligible for shock probation by the next rule day. It's the 21st and that's
The 25th.
I mean, this is that temporarily. We'll fix you that way.
The 25th, Judge, so it should
yeah,
be.
he would be eligible for shock probation next rule day. Okay,
Yeah, because-
so you work with your lawyer and take a look at what drug it is and some other things. I think you may appear to make several lifestyle choices that probably gonna make it difficult for you, but we'll see you then, okay?
Thank you, Judge.
Okay. Okay, now, we have a case that have a translator here. Okay, let's do that. Is that the only translator case we have?
No, Your Honor, I have one.
Okay, well, let's call Maria Rivera then. Translator, you raise your right hand. You solemnly swear or affirm that you've been accepted as a qualified a translator in the Commonwealth Kentucky court system. Thank you very much. Commonwealth versus Maria Rivera, Monroe Circuit case number 22 CR 00106. Are you Maria Rivera? You're here for sentencing.
Yes.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct?
Yes.
Counselor, is there any reason why this lady should not be sentenced today?
No, Your Honor.
Okay, upon a plea of guilty to theft by unlawful taking or disposition of more than $1,000.
Receiving stolen property.
I'm just looking at the offer on the plea. Mr. Stockton?
Yes, Your Honor.
He says it's receiving stolen property, and it says in the offer on the plea agreement, it says guilty to theft, unlawful taking or disposition more than 1,000.
It should be receiving. We can change it if we need.
Okay, so it'd be receiving stolen property of more than 1,000, right? On plea of guilty, receiving stolen property of more than 1,000, defendant shall receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall pay restitution in the amount of $18,419 at a monthly rate of $200 to the Monroe Circuit Clerk's Office, subject to a 5% restitution fee. Monies to the Circuit Clerk's Office shall be applied to restitution prior to any fees or court costs. I'm gonna go ahead and make the fees in for costs 200 and something. I don't know what they're like, 215 or whatever. Ms. Gordon Anderson, do you know what the court costs are over there?
How does court costs?
You don't? It's 215 here. It might be more than 215 there, so I'll just make it 215. So she pays that after she pays the restitution on 18-4. She complied with all the other terms of probation. She shall receive credit for time served. And anything that, any evidence needs to be disposed of, will do so by order. Okay. She can meet with the probation and parole officer tomorrow in Glasgow. You'll need to call over and make an appointment for her.
Tomorrow.
Yeah, will they have an interpreter available there?
I don't know.
Well, she'll need an interpreter there for a couple of reasons. Talk to them, and number two, they'll need to read the conditions of the probation and parole order that she's gonna sign and acknowledge, so she'll need both. What do y'all do as far as that?
We have a Spanish speaking print that we've already had documents already set out that they can just read. But I will let Chase know that she'll be arriving tomorrow and see if he can make arrangements.
Okay. Okay, 10 o'clock. Have her be over there at 10 o'clock. Tell her, and so if the call-in number in Spanish language forms for her to read.
Okay.
And that's that, you can tell her what is the address, probation parole, you know where that is?
It's on Reynolds Road. I can give it to her.
Okay, make sure you give it to her. Okay, thank you very much.
Thank you.
Yeah. What's the other case where we need an interpreter?
Judge, it's Conception Lopez. Case is 23 CR 64.
Is that Concepcion?
Yes, Judge.
You said, I don't know what it's Conception.
That's
Concepcion.
correct.
I put a little accent on it, Judge.
Yeah, that's what you say in Clay County, but if you accuse him of being a conception, he might get all kind of shook up.
Fair, Judge, fair.
Okay, this is 23 CR 0064, Commonwealth, Kentucky versus Concepcion Lopez. Mr. Lopez, were you born in 1977?
Yes.
Yeah, and you don't have a social security number, is that correct?
No.
Okay, we're here on a pretrial conference. What does the Commonwealth have to say?
We have a felony plea. Oh, no.
Not yet. We just got this.
Oh,
My apologies, yeah. Your Honor, we actually just received some discovery. And once I'm able to,
What made you think there was a felony?
Mr. Stockton informed me that there was a plea.
yeah, I don't think we have plea paperwork yet.
You have any objection to this happening on January 25th?
No objection?
Next court date is January 25th. Try to go over this with him by then, okay?
Judge, do you want him here for a negotiating day,
What is the negotiation day?
the 19th?
January 19th? Have him here on January the 19th at 9 a.m. and January the 25th. Both of them are conditions of his bond.
Okay.
Okay, thank you. Does that conclude the,
Yes,
Judge,
sir, that's what they review.
yeah,
Well, Judge, we actually have a Clinton County case if the court would take a plea,
on him?
not for him.
Does it need a translator?
They would need a translator, Judge.
Okay.
Okay, what case is that? Is it on the docket?
It is not, Judge.
Well, I mean, how are we gonna do it if it's not on the docket? Tell Mr. Stockton,
Yes, Your Honor.
they say they have a Clinton County case that's not on the docket. What's that?
I think it's a possession case. It's hard enough for me to get ready for this docket, let alone something get in at the last
Why are we
minute, so I don't
doing,
know.
why are we doing this today?
Judge, we had plea papers executed.
You need to speak up a little bit.
We had plea papers negotiated. Mr. Rodriguez, when we came to court in Clinton County on the 11th, Mr. Rodriguez was not understanding some of the language in the plea.
We'll have him over there in the next rule day. Okay.
But I was just gonna say there was a trial set, so with the translator here, we were trying to do it for the convenience of the court, but we can.
What's the deal now?
There is a trial.
Do you with me? Yeah,
Let me see here.
no, so 20.
Rolling right along here.
January 23rd.
Yeah.
Got the voice here. Does the voice know why we didn't accept this plea?
I don't believe it was on our end.
Are you trying to plead him guilty of misdemeanor? Is that what you're trying to do?
No, Judge, we have the plea completely, again, it's the same plea we had negotiated, executed.
And he didn't enter it last time in Clinton County. I remember now, so I asked for a trial date and you said it in January.
He's ready to enter it today. How do you feel about that?
I don't mind if the court doesn't, if you.
I was just doing it for
Ms.
judicial
Thompson
economy,
doesn't, but
Judge.
if you wanna wait till 11, I
I
don't.
appreciate y'all thinking about my economy here right now, like 100 cases here. Bring him up here while we have a live translator.
Thank you, Judge.
Do you have his pre-sentence investigation report?
Well, it'd be a plea, Judge.
I mean, his plea papers.
I do, Judge.
Will you go with Mr. Bailiff? This is Clinton Circuit Court, meeting by recent agreement here in Burkesville on 23 CR 0047. Commonwealth versus Kelvin Jose Riviera Rodriguez. Are you Kelvin Jose Riviera Rodriguez?
Yes.
I understand that you wish to enter a guilty plea, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment 23 CR 00047?
Yes.
Is your judgment impaired today in any way?
No, I'm fine.
Have you had time to talk to your attorney about this case? Are you satisfied with his advice?
Yes.
You understand that you do not have to enter a guilty plea today.
Yes.
You have certain rights under the Kentucky and United States Constitution.
No.
You have a right not to testify against yourself. No one can make you say anything. A right to speed trial by jury. A right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. And the right to require the Commonwealth prove beyond a reasonable doubt that you are guilty of charges against you. You understand that by entering a plea today, you give up all those rights. Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. Prior to accepting your recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Now I reviewed the offer, Your Honor. I didn't bring my.
You don't
file.
remember it?
No, I don't.
Mr. Bailiff, will you hand that over?
Your Honor, Mr. Rodriguez will plead guilty of fleeing and evading police first degree. Receive a sentence of 5 years. Serve 45 days home incarceration. Shall plead guilty to failure to maintain insurance. $500 fine and cost. He'll receive credit for any previous home incarceration, but he'll still have the 45 days to do. And he'll obtain and maintain gainful employment.
It's a felony plea?
Yeah.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
Knowing your constitutional rights, is it your desire to allow the court to fix your punishment?
Yes.
You understand after any of this plea, future convictions would enhance the range of penalties.
Yes.
Did you sign this document? Is that your signature on there?
Yes.
Okay, let him look at it again. I'll accept the plea, order pre-sentence investigation report, and schedule a sentencing date in Clinton County on January the 11th. And if you'll take this back to Clinton County, if you'll hand that to Jesse. Okay, I'm not gonna take him into custody today, but he'll need to meet with the probation and parole officer over there. Can you provide him a phone number for probation and parole over there?
Yeah.
You'll need to make arrangements to make sure that they have a call-in line to meet with him. And when you want anything on the docket here, you just can't bring it up like this. You gotta call my office and the clerk's office, tell them it's gonna be, we have it on here, okay? You just can't do that.
Yes, Judge.
Okay,
She's supposed to come on.
that Maria Riviera thing, did she come off the month?
Yeah.
Okay. Just, we'll need to get an order signed on that. You'll need to submit an order and have the person that does the ankle monitor to come off. Okay? Kenneth Alexander. Thank you. You have anything for me to sign or anything?
Thank you so much.
Merry Christmas.
Merry Christmas to you too. Thank you.
Commonwealth versus Kenneth Alexander. So moving right along here, we're just. Are you Kenneth Alexander?
Yes.
You born in 1964?
Yes.
Last four digits, social security number 6237.
Yes.
You're here down at the pre-trial conference. What does the Commonwealth have to say?
Your Honor, we need one more negotiation date. The victim has not responded to us, and we're gonna have to bring her to
What
court.
is your negotiation day again?
January the 19th at 9 a.m.
January 19th, be there, and January the 25th is the next court day here. Both of them are conditioned to your bond. Okay. Richard Armstrong. Rainy.
Just trying to think.
Richard, give me the document for writing. Commonwealth versus Richard Armstrong. 23 CR 0080. Are you Richard Armstrong?
Yes, sir.
You're represented by Office of Public Advocacy in District Court, correct? Public Defender's Office, is that right?
Yes, sir.
Okay, I'll continue that appointment. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you possession of controlled substance in first degree, possession of drug paraphernalia, possession of marijuana, failure to maintain insurance on a motor vehicle, failure to register or transfer a motor vehicle, no registration plates, expired registration plate, careless driving, and failure to wear a seat belt. Counselor, you acknowledge the identity of your client received an indictment, waive formal reading, enter plea of not guilty, preserving all pre-trial motions.
Yes, Your Honor.
Okay, he'll be here on January 19th at 9 AM for negotiation and January 25th for the next court date. Both of those are conditioned your bond. You understand that?
Yes.
Okay. Cody Appleby's next. You can go. Cody Appleby. Commonwealth versus Cody Appleby. 23 CR 0089. Are you Cody Appleby?
Yes, sir.
Born in 1990.
Yes, sir.
Last four digits, social security number 3629.
Yes, sir.
Okay, you're here today on a pretrial conference. Was the Commonwealth have?
Your Honor, we just received both labs in this case on December the 18th and furnished them to Mr. Pennington, so we'll need another date.
January the 19th for negotiation and January 25th for your next court date. Both of them are conditions your bond. You realize that?
And Judge, speaking of which, Mr. Appleby has been on under bond as far as electronic monitoring for some time. You know, I understand the delay.
Why was that? We have some, is he got some rabbit in him?
He's a low risk.
What's he charged with?
He's got a possession and a DUI.
And Judge, I guess one of the
DUI third is the reason. That's the reason.
Judge, Mr. Appleby actually works with Junior Smith. I mean, I understand Junior Smith does the monitoring and can't monitor him at night, but for day purposes.
Where are you living at?
Joe Scott Ridge
By yourself or somebody living with you?
with Anthony Jansen.
Yeah, well, he worked with you?
Yeah.
Okay, I'll let you come off the ankle bracelet, but don't let us down.
Thank you, Judge.
Is it you, are you driving? You got a valid license?
No, I'm with Sheila. She was going to take him back. Sheila Willis. Yeah, I ain't been driving.
But don't be driving.
No, I ain't.
Okay, see those two dates.
Thank you, Judge.
Yeah, Bronny Bays. Combo versus Bronny Bays, 22 CR 0026. Bronny Bays, born 1984, last four digits, social security number 5442, right? Okay.
Yes, sir.
What do you have?
We met with state police on this. We're waiting on a supplemental report. May have to go back in front of the grand jury again, so we can have a few more months. It should be ready to set for trial. We had difficulty on this one, Judge, because the state trooper went to Bowling Green and we've had to pick up another officer trying to get some work done. The Clay, Mr. Hunley's met with them.
Yeah, let's, I'm gonna set it for the next rule day.
Okay.
And if we can set a trial date without waiting for rule day when you get the information. Correct?
That's fine.
The next, you'll be here on January the 25th. Christian Bolt. Cromwell versus Christian Bow, 23 CR 00102. Are you Christian Bow?
Yes, sir.
Come on up there and speak up a little bit. Were you born in 2004?
Yes, sir.
Last four digits, social security number 4270.
Yes, sir.
Here for a pretrial conference.
Mr. Cross and I couldn't reach an agreement on this. I attempted to call Deputy Watson to discuss the case with him when we was doing that. He worked night shift. I'd like to have one more pretrial and have Deputy Watson there. If he can't settle it, I'll get a trial date.
I agree, Your Honor.
Let's have a negotiation day, correct?
Yes, 19th.
You'd be at January 19th and back here on the 25th. What's the charge here?
It's fleeing and evading.
Okay. Okay, Thomas Carson. Commonwealth of Kentucky versus Thomas Carson, 23 CR 00104. Are you Thomas Carson? Are you Thomas Carson? Can you hear?
I hate to see it.
Mr. Bailiff, come over here. Okay, is that better?
Yes, sir, yeah.
Okay. Commonwealth versus Thomas Carson, 23 CR 00104. Mr. Carson, were you born in 1952?
Yes, sir.
Last four digits, social security number 5176.
Yes, sir.
5176. Do you know what your social security number is?
Yes, sir, I do.
Okay, I hope so. What does the Commonwealth have to say about Mr. Thomas Carson?
Your Honor, I met the victim this morning. I think there's going to be additional charges. So if we could have one more pretrial.
Well, you want to, negotiation day on January 19th. Hopefully you can tell them what the additional charges are, but then.
I was caught blindsided before the grand jury this morning myself. The victim caught up with me and Mr. Penny and I discussed this at the last pretrial. I thought we were getting close to an agreement on it. But evidently we may not be because the victims had a change of heart in this case.
Negotiation day, January 19th, next court date, January 25th. What is the charge?
These charge wanton endangerment, shooting toward their house, plus evidently where they live close together and there's been at least two different packages of some value delivered to Mr. Carson's house. And that's where the additional charges may come from because he's not giving those to where they should have been delivered to. So that's the ongoing problem we've got in this case.
Blame it on UPS or?
Yeah.
FedEx probably.
I guess that's kind of like the Monopoly game.
Oh,
Thank you.
FedEx, we get them indicted, just be all right. Okay. See you those two dates, January 19th, January 25th, okay? Kevin Cooper. Kevin Cooper. Commonwealth of Kentucky versus Kevin Cooper. Are you Kevin Cooper?
Yes, sir.
You born in 1997?
Yes, sir.
Last four digits, social security number 9637.
Yes, sir.
You're here in 23 CR 0073 for pretrial conference. What does the Commonwealth have to say?
Diversion, please.
What is this? Motion's been tendered, sir, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same in person, name, and indictment number 23 CR 0073?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence which the Commonwealth has against you?
Yes, sir.
You believe you've been fully informed about the case?
Yes, sir.
You understand that you not have to enter a guilty plea today?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution for right, specifically, I need to know that you understand those rights. You have the right not to testify against yourself, no one can make you say anything. Speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and talk to them, all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to fill this matter to a higher court if you leave, and right to apply the Commonwealth to beyond the reasons that you're guilty of charge. Understand that by entering a guilty plea today, you give up all those rights. You understand that? So now may consider Commonwealth's recommendation, I may apply any range of law, any range of sentence provided for law, I don't have to accept. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now I'm gonna do some, couple of questions as far as your eligibility for pretrial diversion. Have you previously been diverted in the last 5 years? Have you had any felony convictions in the last 10 years? Certainly. Well, I mean, is there a doubt about it?
He's got a misdemeanor diversion in Adair County, Your Honor.
Mr. Stockton, does the misdemeanor diversion disqualify someone from getting this diversion here?
I don't think it is because I don't think there's anything in the statute that allows a misdemeanor diversion. It's commonly done in district courts. There's no statutory
What we used to
construct.
call common law diversions.
Yeah, so I don't think it does.
You understand that if you fully complete the diversion, the charges will be dismissed, pretrial diverted. You understand that if you do not complete the diversion successfully, you could be brought back in front of the court. I could revoke your diversion and schedule sentencing. In that situation, you would be a convicted felon, and that can be used against you in the future. You understand that?
Yes, sir.
What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to failure of owner to maintain insurance, first offense, the defendant shall pay a fine of $50. The sawed-off shotgun shall be returned to the defendant upon him providing a federal tax stamp. Otherwise, it shall be forfeited under the Kentucky law after 6 months from the entry of this plea. The defendant agrees to be assessed by the social services clinician and will follow any recommendations thereof. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that your understanding of the plea offer?
I'll make one correction, Your Honor. On this actual original, we amended that to failure to produce insurance card. It's a different statute with a different penalty.
Yeah, it should have been, that was the reason we wanted a $50 fine. That's correct.
Are you pleading guilty because you committed acts charged in the indictment as amended?
Yes.
Knowing your constitutional rights, I've explained to you, is it still your desire to give up those rights and allow the court to fix your punishment?
Yes.
Is that your signature on the document?
Yes, sir.
Could you retrieve that? I noticed some reference to a shotgun. What's the deal?
When we negotiated that, it's legal to have a sawed-off shotgun in the Commonwealth of Kentucky if you have a federal tax stamp that's properly registered. And they had one, but they didn't have it registered. If they can get it registered in time, they'll get it back. If not, it's gonna be forfeit.
And they're fine with forfeiting it, Your Honor. His mother had bought it at a yard sale.
Well, that's where they got the gun where they killed Jacques Gilbonsky at. They got a court sale in Mount Sterling. The fact that you get a machine gun at a court sale doesn't make it not a machine gun or doesn't make it not a sawed-off shotgun.
Well, I hadn't researched the law. I didn't know that. You know, about looking at sawed-off.
About yard sales or?
Know about this shotgun. Didn't know that about LeBron.
Well, now you know about court day in Mount Sterling.
Yes.
I don't know about, where was the shotgun? You can look into all that, okay? You do.
That's what's gonna ask you, how's he gonna have a shotgun?
It's what we'll do here.
Okay.
Big kinds of.
Okay.
Yeah, I want you to look into the shotgun though when you do this interview with him. Sentencing will be scheduled on January the 25th. You know, wait a second here. Let me, Mr. Stockton,
Yes. I'm just skeptical that they can even get anything under the current environment.
will you leave Mr. Stockton alone while I'm talking to him? Move on over here, go over it.
His mother said that she's filed a forfeit that.
Okay.
Well, I'm not so sure. I'm finding, I need to know something about the shotgun. Where was the shotgun? What's the deal on the shotgun?
I believe this is the case. I can't remember
I've got the
Even
I got
if-
the citation here, let me read.
Yeah, it's not addressed in the police.
Let me
report.
read the
You know what's going on
citation.
there?
He said that he did assemble it, so that way they didn't lose all the parts.
Okay, according to Mr. Poindexter, it was disassembled. This is not addressed in the citation or the police report.
It
We
is
had
too,
trouble.
it is too. I also discovered a sawed-off shotgun inside the vehicle.
Yeah, but it was
After I-
disassembled.
wait, after I discovered the items, I gave him money. So they found several bags of plastic substance, which are crystal, several plastic bags with crystal substance, a glass pipe and crystal residue, and a scale, and a sawed-off shotgun. I'm
This
not-
is disassembled.
Well,
That's what I was getting ready to say, it wasn't addressed in the report, that it was disassembled, that Deputy Watson put it back together so he wouldn't lose part.
well, the guy's got scales and and bags of crystal residue in there.
Well, the lab report. So here,
I think it was only 0.06.
we can try the case, but it is a residue case. Yeah, 0.066 hundredths of a gram. But if it's at a trial date, I'll try it and see what it does. That's what the court desired.
Well, I'm just asking questions about it. I don't, I read the thing, he's
Yeah.
got scales here. I don't know.
The Commonwealth's hands has been strong since House Bill 463 when they passed that and basically decriminalized methamphetamine, so.
I wasn't there then.
Yeah, I can blame the legislature.
Well, I'm gonna take this under advisement. We'll come back here on the 25th of January. I'll decide what I'm gonna take consideration for you about.
Yes, Your Honor.
Okay.
Your Honor, he wanted me to ask about his ankle monitor. He's been on an ankle monitor since the arrest as part of his bond condition. He was asking if he could.
He can come off the ankle monitor, but he needs the rest conditions bond he needs to comply with. Okay?
Yes, sir.
I am currently employed, so I work one day and I will,
Do what?
I'm currently working too, so.
Good, good. You can go to work. Give me an order to take a ankle monitor off of it.
Yes, sir.
Brett Davis. Where's Brett Davis? Anybody know about Brett Davis?
On Zoom, Your Honor.
Why is Mr. Davis not here?
Because you told him not to be here. You told him to appear remotely.
Where's he from?
Birdstown, but he's working away.
Yeah, I didn't know.
When-
It's just Commonwealth's
When did
motion.
I tell him that?
Last time he was in court.
I wasn't in court last time, so.
We're here for a pretrial conference.
Commonwealth has a motion to continue the trial, please.
When's it scheduled for now?
It's scheduled for next week.
All right.
Yeah, it was said I wasn't here last time and it got set over my schedule and I asked the court for all of the date. Because I couldn't be ready next week.
It's scheduled for the 27th.
28th, I think, maybe next Thursday.
Yeah, well, when you want to set it?
Whenever the court
Judge, that
wishes.
trial's already been continued. An order of continuance was entered.
Yeah, I already said, I can't understand why it's
Okay.
on here, but you want to set it for a trial date now?
Yes. Yeah, I don't think I'll get any resolution without trial date.
Well, it's a case of restitution and quite frankly, the more time we got, the more greater possibility there is. I'm meeting with Mr. Davis this next week.
What's the charge?
Mr. Davis allegedly took over $60,000 to build these two travel nurses a house. And depending on his version and my version, Mr. Cross's version, he did about $3,000 to $10,000 worth of work. And skipped
They
out.
didn't get their money's worth, Your Honor. The question is it a criminal matter? But we're trying to resolve it through some sort of repayment arrangement, but right now we can't.
Let's just go ahead and set it for trial.
Way to use this.
Yeah, I signed an order in this case on November 30th. Here's what the order says. It's ordered that the trial for December 28th, 2023 be continued and a pretrial conference be held on December 21st at 9 a.m. It is further ordered that the defendant shall appear before the court on December 21st, 2023 in person.
Well, that's not what the court said in open
Well,
court,
you
Your
know,
Honor. I'm sorry.
the court speaks through its orders. I don't know. I can't remember what the court says. You're always telling me what the court said 2 or 3 times ago. But I don't, I mean, I'm just looking at the order. So you want to set a trial date?
Yeah, sure.
Your Honor, my memory is faulty. I apologize, but that was what I told Mr. Davis. It was my understanding that because he was working away, that he appeared remotely.
It's a 1-day trial. How much time are you gonna need?
I don't have very many.
It might get into two, Your Honor, because it's a question of experts and what work was done and.
Well, I'm not gonna notice that you've got an expert.
Well, somebody to come in and testify to what it's worth. We got.
Got to tell them what they need to say first.
Yeah.
I'll lose service. Let me get over this. Got my heart, man.
What about April 8th and 9th?
Fine with me, Your
Honor. Your Honor, Tuesday, April 9th is a, yeah, we can do it. We can.
And file the case.
Your Honor, I might suggest a pretrial at, February.
There's no reason to have a pretrial unless you have any motions
Well, we may, and
to
then
file. Well, if you do, Let's make it the 15th and 16th. Sixteenth and 17th. 16th and 17th.
That's fine for Commonwealth.
I'm sorry. We're still the 8th and 9th.
16th and 17th.
16th. If we go over and visit.
That'll work. Mr. Davis, give me a call. Give me a call, Mr. Davis, this afternoon.
Okay, thank you.
Billy Huddleston. Commonwealth versus Billy Huddleston. 23 CR 00101. Are you Billy Huddleston? You born in 1962? Last four digits, social security number 3418. What does the Commonwealth have to say for Mr. Billy Huddleston?
We had a tentative plea, Your Honor, but I think Mr. Petty didn't want to look and see if there was any suppression issue before he entered the plea because he entails prison time.
That's what?
Prison time because he's in possession of felony conviction, in possession of a firearm.
But Judge, if we don't need a negotiating day, we can just come back on the 25th to have a plea or set a trial date.
I don't understand what the problem is. What's your problem?
I'm looking at the evidence to see if there's any,
Well, had you
Motion.
signed a plea agreement before that?
excuse me,
Had he entered into a plea agreement?
no, Judge.
I thought you said something about a plea.
I said we had a tentative in
Oh,
case,
okay.
that he doesn't find any
Or
issue
the
with the
suppression,
stop.
or the suppression failed. So if we come back on the 25th, we do not need another negotiating day.
Are you gonna file a motion for that day?
Or enter a plea.
We'll file a motion for that day or enter a plea on that date.
Yes, Your Honor.
We'll set a trial date.
Yes, Judge.
Got that date, January the 25th. What kind of weapon was it?
I'd have to look at the file.
22.
It's a 22 rifle.
Yes, 22 rifle.
Jerry McClister. Jerry McClister.
Judge. Mr. McClister's sister was in this morning. She actually brought in a letter. He's in the hospital right now in TriStar Centennial Hospital in Nashville.
You got a copy of the letter?
Excuse me?
You have a copy of the letter?
I do, Judge.
Give it to Commonwealth.
And Judge, we have a plea. It's gonna be a misdemeanor plea, but Judge, there's a DUI. Otherwise, I would ask the plea and abstain from Mr. McClister's. I acknowledge I can't do that with the DUI.
Yeah, I think you would have to be here at the DUI.
Scheduled for January 25th.
I'm just making a copy of that for my file. I thought it was forgery because I could read the doctor's writing, but a registered nurse signed it, so that's probably the reason I can read it.
Charles McCoy. This says a pretrial conference and a competency.
Your Honor, if he will not stipulate that he is incompetent to stand trial, then I need to have a hearing, because if he's incompetent to stand trial, he's not allowed to have a valid driver's license under Kentucky law. And we got that changed in the legislature a few years ago. And so I'm asking for an order to be entered that he's incompetent at this time.
And Your Honor, we have no objection to
Where is
that.
it, Mr. McCoy?
Your Honor, he was given notice to be here today, but he has struggles, so he's not here. I believe his sister's here.
This is one where we filed a 202A petition. Court ordered him to a psychiatric hospital, and I think, how long did they keep him?
Well, he beat him back.
He beat us back, yeah. So.
But the guardianship case is ongoing in district court, Your Honor. I believe they're
What's the
set.
status of that? Parenting. Did you get behind the microphone where I can hear you?
I believe Mr. Nick Carter is appointed in the guardianship case in district court.
Well, I mean, he's in Jordan or somewhere.
He hears by Zoom from Jordan, yes, sir. So far.
He did
Yes, sir, he did yesterday, not on this.
on this
but-
case.
No, sir, on his other cases that he has.
Well, I was asking about this case.
I was looking for the issue for that.
I think it may be after the first of the year, Your Honor, but I'm not sure the exact
January
date.
what? January 24th.
But we had a case in Clinton County where somebody was incompetent to stand trial, and they were in an accident, and the child was killed during Halloween. And when Sarah Beth Gregory was in the Senate, she got the law changed where you can't have a valid driver's license if you're incompetent to stand trial. So that's the reason I wanted to go with it. My understanding is he's trying to become licensed.
Okay, well, I'm gonna order him not to drive
Actually, Your Honor.
and order him not to apply for a driver's license or his bond condition. Okay? And then you want to put it to the February rule day to see how the competency hearing goes in district court? Because they're on the 27th, did you say?
24th.
24th. Well, let's schedule it for the 25th. Is that a trial for the 24th or?
I believe so, Your Honor. It was the trial, but I don't know if Mr. Carter will be able to appear for a trial via Zoom. I'm not in that, so I'm not sure, but I think that may.
Maybe that KCPC needs to reevaluate him since Western State thinks he's competent. He's all right to be out in the public.
A pretrial conference stage, Judge.
Okay.
Their jury trial is set for January 29th in district court for the mental health.
Yeah, let's take it out to February 29th. And I would issue a warrant for failure to appear, but I don't want to send him back to jail. He's been up there for years, it seems like,
Thank you, Your Honor.
But I cannot ignore it. If he doesn't come, I can't ignore it. So make sure he knows about the conditions and give and you draft an order, Mr. Stockton, and give a copy of it to the circuit clerk's office.
Order
that he shall not apply for a driver's license and shall not drive a vehicle. Okay. Okay, thank you very much. His sister's back there. Does she need to consult with his sister? Does she know anything that would help the Commonwealth at all or what?
She's calling, Your Honor. Been very helpful.
Okay, thank you. Commonwealth versus Cheryl Prophet. Are you Cheryl Prophet?
Yes, Your Honor.
It's 23 CR 00100. You born in 1966?
Yes, Your
Last
Honor.
four digits, social security number 1603.
Yes, Your
Here
Honor.
for a pretrial conference.
Yes.
What do you have, Mr. Stock?
Your Honor, we didn't make any progress at the last pretrial, but Mr. Cross has furnished me some information I want to go over with Sheriff Williams this morning. So we could have one more. If not, we get a trial.
You want to have a
Negotiation.
negotiation day on January 19th, and the next pretrial is on January 25th.
Thank you, Your Honor. Ms. Crawford, when we first appeared, the court placed her on a curfew. She's been at Monroe County Medical Center for 22 years, never been in court for anything in her life. And I believe that's been about.
It
all we know.
interfered with her work? What's she charged with?
There was an assault third, Your Honor. This is the case with Sheriff Williams at was it a raceway?
I remember.
Her
I
husband was in an
remember
altercation and then she got involved because Sheriff Williams was trying to break it up.
Yeah.
I believe it. I don't
You can talk to the Commonwealth about it. What's your position?
think they've
I
got an issue.
want to consult with the sheriff. If it's all
Okay,
right with
well,
him, I'd be all right.
Y'all consult, you submit an order.
Okay.
I mean, I just don't go for assaulting a police officer. The accusation,
Well, and again, that's all it is an accusation.
it's all anybody up here is, and I have to set bonds based upon whether I protect the officers or not that are there. And if there's an accusation that someone attacks a police officer charged, she's right to be presumed not to be guilty. But did she act out last time she was over here or something about not getting out or anything? I don't know.
I will. I've got that information. I'll give it to the sheriff.
Thank you.
Okay, well, and if he has no objection, I don't have any problem signing, modifying her bond. Okay. Jesse Randolph. There's an active warrant out for Jesse Randolph.
He's here now.
Why is there an active warrant out? What was it?
Judge, he had removed his ankle bracelet.
My understanding, according to Junior Smith, is he was working at Patriots. It was a false alarm on it. It went off. And Mr. Randolph took it off. He thought he would violate it. He left it at Patriots. His mother called me and I told her, I said, you need to get back with Mr. Smith so he can get reinstalled. That way he can stay out of jail. Well, then she called me back and said that they didn't have the money to get it put back on. So that's really all I know at this point. And then now he's showing up to court, but he never did turn himself back in to either the jail or to Mr. Smith.
And Judge, to update,
You need to speak up a little bit.
Judge, Mr. Randolph did attempt to get the bracelet, I guess, re-put back on.
Why did the bracelet come off?
That was what Mr. Stockton just alluded to,
He took
the
it out.
false alarm, then he removed it after the
What do you
false
mean the
alarm.
false alarm? Does it go off? The bracelet itself goes off?
Evidently, according to Mr. Smith, and I'm getting my information from Mr. Smith, it went off and instead of Mr. Randolph being calm, cool, collected and was calling Mr. Smith, he panicked and he took it off. And he's lost his job over it. He did the wrong thing. I mean, and now he's here in court. That's one good thing. And then he couldn't get it put back on according to his mother because he didn't have the money. That's all I know.
And the order, they actually needed a subsequent order once it was removed. They said they couldn't put it back
Junior
on.
needed court order.
Correct.
Okay,
So even if they would have the money, it was inability.
okay.
And Judge, I will say, as part of the plea, there is a significant amount of restitution that Mr. Randolph owes actually to the city of Burkesville for some property damage. That was part of the plea, is for him to pay the restitution payments, and it's my understanding he's actively seeking employment, is trying to go back to Patriot so he can start that restitution. Judge put him on a ankle monitor almost defeats the purpose, because that money that could otherwise be used for restitution is being, paid back into the county.
Very on.
Something not right about this.
I think, and I can't remember if I put in the plea or not, but he needs some mental health treatment.
They has to be.
Anxiety issues, if not more
Step away
severe.
and talk to your lawyer. You tell him what you want to say. It's been a day, right?
This is the case that I prefer you to any private, based on the reason that I don't need money, to know what I'm using.
Okay. Just want me to continue it next month.
Yeah.
Okay, but can't stop. Well, we'll get on the record. Let's continue this to next month.
Thank you, Judge.
January 25th. The Commonwealth says that they want to have a discussion in camera on this. So it folks while you were over there, right? I'll withdraw the active warrant. And what are conditions of his bond now?
It's on ankle monitor. He was like, it's a standard curfew.
Okay, I want him on the standard curfew. Where are you living at now?
Monticello, has to be,
Where? That's a big town. You live
It's,
with your mother or you have
yes.
your own place or what do you have?
it's my mother and father.
Are they here?
My mother.
His mother is, Judge.
Okay, well, he needs to stay at home. He can only leave with work, church, or the doctor.
I go with her.
Work, church, and I don't want you to say anything else, okay? You get with the Commonwealth, we'll be back here on January 25th.
Thank you, Judge.
Hannah Scott. Commonwealth versus Hannah Scott, 21 CR 00140. Are you Hannah Scott?
Yes.
You're born in 1994. Last four digits, social security number 1267.
Yes.
Okay. You're here on a pretrial diversion revocation in 21 CR 00140. What does the Commonwealth have to say?
Your Honor, Ms. Scott has a 5-year sentence for burglary, 3rd degree. It looks like she's had 5 positive for methamphetamine. I think at this point in time, she was positive while participating in SAP-IO, not SAP-IO, the IOP. I think that the Commonwealth would either want to revoke and go into drug court or that she be assessed for drug court this time. If she's not doing very well on probation.
And Judge, we have no objection to a referral to the specialty court. Ms. Scott tells me she.
I can't hear you.
Ms. Scott tells me she would very much be interested in specialty court.
But I don't know that she should be out. I'm fear for her own safety. She's had 5 positive tests and not, doesn't look like she's slowing down. So if the court needs to revoke her to do that and get her in drug court, I don't know, but.
You gonna stipulate or you want to hear it?
We'll stipulate, we would ask to increase the frequency of tests and then let Ms. Scott remain out of custody.
Well, this is. We probably should have had a hearing because this is the one where her mother There was a community complaint from her mother and she was seeing things and things. I'm just worried that she might overdose and die.
Well, we sent her up here and then they had to transport her.
Yeah,
She's in custody.
yeah.
And we'll have a hearing on,
25th.
25th.
Yes, Judge.
Hold a pre-sentence investigation while revoking her pretrial diversion.
Do a drug court.
Take her to custody.
No.
Jennifer Spears. Jennifer Spears. Commonwealth versus Jennifer Spears, 23 CR 00091. Are you Jennifer Spears?
Yes, sir.
You born in 1985.
Yes.
Last four digits, social security number 6051. You're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, this is a case involving restitution from, on a district court estate. I think if we can have one more time, we can arrive at a number and get this resolved.
January 19th for negotiation
Yes.
and January the 25th. Both of them here at 9 a.m. conditions of your bond, okay? Ella Stearns. Ella Stearns, there's an active warrant out for Ella Stearns.
She's in CIC.
Okay, Jamie Stearns. Commonwealth versus Jamie Stearns, 23 CR 0098. Are you Jamie Stearns?
Yes, sir.
You were born in 1977. Last four digits of your social security number 4748.
Yes, sir.
You're here on 00098 00105. What does the Commonwealth have to say?
I believe, I'm trying to recall correctly, this is the one where you had the Wayne County case?
No, this was, we had labs in one, but not. the
That's
other.
correct, yeah. We're waiting on a lab report in one case.
You want to set a negotiation date just in case you get the labs back?
Yeah, we'll call.
Negotiation day on January 19th and January 25th, subject to contacting you otherwise. Christopher Terry, active warrant. Okay, I'll get up in just a minute. Christopher Terry,
Yeah, we'll put him in CIC.
okay, Jennifer Wise,
That's.
Jennifer Wise. Come up for the Jennifer Wise, 23 CR 00103. Are you Jennifer Wise?
Yes, sir.
Born in 1980.
Yes, sir.
Last four digits, social security number 7617.
Yes, sir.
Okay, we're here on a pre-trial conference. What do you have?
Judge, we have a resolution.
Yeah.
Felony, or excuse me, diversion plea.
What is the charge here?
It's possession of controlled substance. Miss Wise has hardly no criminal history, and I conferred with the officer on this case, and he's fine with it.
Motion been tendered says you wish to enter guilty plea. Is that correct?
Yes, sir.
Are current uninfluenced drugs or alcohol?
Okay.
It is plea freely and voluntarily given. Are you the same person named indictment number 23 CR 00103?
Yes, sir.
Have you discussed this matter with your attorney?
Yes,
Are
sir.
you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You have certain rights under the Kentucky United States Constitution. You do not have to enter guilty plea today. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. The right to be represented by counsel at all times. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require Commonwealth to prove on the briefs without your guilty charge against you. Understand that in a guilty plea, you give up all those rights.
Sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Then I do not accept the Commonwealth's recommendation. And decide to impose a harsher sentence. You have the right to withdraw or you plead guilty and proceed to trial. I'm gonna ask you some preliminary questions. Have you previously been diverted in the last 5 years?
I didn't hear you.
Or have
I
you
didn't-
previously been diverted in the last 5
No,
years?
sir.
You have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion program, the charges will be dismissed, pre-trial diverted, and you can expunge your record. You understand that?
Yes, sir.
You understand if you do not fully complete the diversion program, it will be brought back before the court I revoke your pretrial diversion, I schedule it for sentencing, you'll be a convicted felon, that can be used against you, understand that?
Yes, sir.
What's the Commonwealth's recommendation?
Your Honor, Ms. Wise will plead guilty to possession of a controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5. She'll be assessed by the SSC, follow all recommendations. She'll obtain and maintain gainful employment, and all evidence in this case will be destroyed.
Is that what you agreed to?
Yes, sir.
Is that your signature on the document? Look at her signatures.
Yes, sir.
Knowing your constitutional rights, it explained to you that it's still your desire to give up those rights to enter a plea of guilty and allow the court to fix your punishment.
Yes, sir.
I'll accept the agreement on the diversion order. I'll sign it in a few minutes. You'll need to meet with the probation parole officer right back there, okay? What are the court costs in the case?
$215.
$215. You need some time to pay that?
Little bit, please.
Okay, I'll let you pay it, $40 a month. The first payment due 30 days from today, okay?
Sure.
Okay, Cinda Young. Cinda Young. Cinda Young. Are you Cinda Young?
Yes, sir.
This is 23 CR 0079. Miss Young, were you born in 1959?
Yes, sir.
Last 4 digits, social security number 6221.
Yes, sir.
You're here for a pretrial conference. You understand that?
Yes, sir.
Okay. What we got in this case?
Diversion plea.
I understand that you filed a motion that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea free and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 0079?
Yes, sir.
Is your judgment impaired?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
You read the evidence Commonwealth has against you, but you fully understand the case. You understand you do not have to enter a guilty plea. You have certain rights under Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes,
You have the
sir.
right not to testify against yourself. No one can make you say anything. Right to speak trial, but you be right to be represented by counsel at your true trial. Right to confront and cross-examine all witnesses called this against you. Right to produce evidence. Right to call witnesses in on your behalf and have process history to their attention. Right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge. You understand the entering guilty plea today that you give up those rights. Now, I may consider the Commonwealth's recommendation when I apply and range of sentence provided by law. I don't have to accept it. And then I don't accept the recommendation decided to impose a harsher sentence. You have the right to withdraw your plea. What's the Commonwealth's recommendation?
Upon a plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. Defendant agrees to be assessed by the social services clinician and will follow any recommendations. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you understand?
Yes.
Okay, have you had previously been diverted on anything in the last 5 years? You had a pretrial diversion in the last 5 years, you had a felony conviction in the last 10 years.
No, sir.
Are you presently on probation or parole?
No, sir.
Okay. You understand that if you violate this, you'll be brought back in front of the court. And if I revoke your pretrial diversion, I have pre-sentence investigation report, you'll be a convicted felon. Do you understand that?
Yes, sir.
And that could affect you. You haven't had another felon. Okay, knowing your constitutional rights explains still your desire to proceed, enter the plea and allow the court to fix your punishment.
Yes, sir.
Is that your signature on there?
Yes, sir.
Okay, I'll accept the agreement. You need to meet with the probation and parole officer. Do we have anybody else here live? $210, $30 a month, starting 30 days from now. You can tell her, go back there and tell her that. Okay, we're gonna take a short break here. And then grab a piece of
Randy, when he comes back, he'll be ready for grand jury. They're paid in
Yeah, I've seen him down. I've seen him on that.
I've been getting all those eating on fresh fish. I've been boiling them every year.
Every day, something. So I was in the city, something within that last week. And when I was home, I was like, in Washington, Sunday.
You got freaks.
And that's 30 seconds. Well, Washington, it's not. Well. Judge thought it's that's the judge's question and two different prosecutors. No, Friday.
Yes, well, tentatively, yes. At least the first, well, yeah, at least first quarter.
Enough going and you Candace was begging to come back.
No. I don't know what it is. It must not like dealing with you.
It's like. Y'all leading through back.
I'm here.
They put, 2009, not in 2017 on the card.
Yeah, what they need to be on, I know where you'll be for that. Use it all, I will be here on Saturday.
Everybody be seated, that's fine.
Yeah, I don't know if it was flying.
Ladies and gentlemen, the grand jury, have you finished your work for the day? Who's the foreperson? You still the foreperson? Will you retrieve that for me, Mr. Taylor? Now, there had been, this is supposed to be their last thing. There had been some talk that there was a vote taken among members of the grand jury, said y'all wanted to extend your service for another 6 months. Was that correct, or? Mr. Bailiff, I thought that. Okay. It appears everything is in order here. As I've told you before, we'll take a look at these, get them entered in the computer, make a decision on whether we need a warrant or summonses, depending on whether in custody or out of custody. Now, the new grand jury will be sworn this afternoon. Is that right? So unless you're called into special session between now and about 2 o'clock, your service is finished. When can they expect their checks? When?
January. After we close up.
So they're not gonna get it by Christmas? All the other clerks get their jurors' money by Christmas. But I guess that's okay. Okay, well, thank you so much for your service. I know it's an unpleasant thing to hear all about the troubles and trials that people are going through here, but it's a necessary and important part of the judicial system. The most important thing that you do is to make sure there's no one person sitting here in a robe or one person sitting somewhere in a suit that can bring somebody in and charge them with a felony without at least 9 out of the 12 people of their citizens agreeing that there's probable cause. And if you think about it, that's a pretty important safeguard so that nobody gets too much authority placed in their hands. Thank you for your service, and you're now excused. And the good thing is you won't have to serve on a state court jury for 2 more years. So thank you very much. You're excused. You can take these. Okay, now let's go to the Adair County Detention Center. We're just an hour. Hold on a second.
Let me make a note. He's gonna be in some live. I don't think it'll straighten up. Then Kenneth Neal. He's not on the docket today. Yeah, he's on the jail docket. I didn't know he was in custody.
Okay, Adair County. We'll move over here. Get lined up with you here. First case we have is Crystal.
Okay.
Yeah. Crystal Ashcroft, is that correct?
Yes.
You kind of center that camera on Miss Ashcroft a little bit. There you go. Okay, this is 23 CR 0069, Commonwealth of Kentucky versus Crystal Ashcroft. Ms. Ashcroft was born in 1979.
Yes, sir.
Religious social security number 5 is 007. You're here for pre-trial conference. What do we have?
We got a plea worked out, Your Honor, but we'll probably need to do it next month since she's in jail. It'll be, she's gonna be a state prisoner out of Adair County, and I've got a plea worked out to run something concurrent here on this case.
Okay, set her for January the 25th.
Yes, Your Honor.
They say they've got a plea agreement worked out with you, Miss Crystal Ashcraft, but they want to do it on the is she already a state prison?
She is sentenced in Adair next month.
What day?
I think it's January 9th.
She will be becoming her employee.
Whose dime is she on there?
Madison
help-
County.
Madison. Jail, whose account is Miss Ashcroft on?
She's stayed in my city. She's state inmate.
State inmate, okay, thank you very much. We'll see you January the 25th, okay? Keisha
Thank
Crawford.
you.
Keisha Crawford.
Yes.
Commonwealth versus Keisha Crawford, 21 CR 00147. Are you Keisha Crawford? Are you Keisha Crawford?
Yes.
Okay, we're here on 21 CR 00147. Miss Crawford, were you born in 1998?
Yes.
Last four digits of your social security, ma'am, are 2982.
Yes, sir.
We're here on a probation revocation. What says the Commonwealth?
It's the officer on there.
Yes. Officer Burton.
Officer Burton. I guess just take some testimony, Your Honor. I've misplaced my file. This was a late add-on.
Okay, Officer Burton, would you raise your right hand, please? Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
What's your name, with whom you're employed?
I am Officer Caitlin Burton, and I am employed with the Department of Corrections, Division of Probation and Parole.
Okay, you may proceed, Mr. Stock.
Ms. Burton, have you been supervising Ms. Crawford?
She was transferred to my caseload on April the 11th of 2022.
Okay. And have you been attempting to supervise her since that date?
Yes, I have been.
And has she had any violations since that date?
Yes, she has.
And can you just give a brief summary of those?
Yes. On November 9th, 2022, there was a previous violation report for a use of controlled substance methamphetamines from June 2nd that I had provided to the court, where she was assessed by the social services clinician to enroll with outpatient counseling with interest for 16 sessions. The report in November of 2022 was for a use of marijuana, where she also failed to make restitution. So we referred her back to the SSC at that time, and she was given a marijuana education packet at that time. On 11/18, oh, go ahead.
No, go ahead. I was just going to ask, when was she supposed to report again?
Okay. She, on the next report from November 18th, 2022, I had filed another report for absconding because she was supposed to report on November the 10th. On November the 14th, we attempted to make contact, and I had received a message that her phone was disconnected. I then tried to call her family, and they state that they hadn't spoke to her for a few days. And then on November the 18th, Officer Harvey and I attempted to do a home visit at the last known residence, where they provided me a receipt where they were supposed to be living at. And when we got to the lot at the campground, their entire camper was gone.
So my understanding is you've not had any contact with her then since November the 3rd of 2022.
That is correct.
Yeah. No other questions?
Officer, are you aware of the circumstances as to where Miss Crawford was apprehended at?
Yes, I had received a complaint advising of her location, and I informed the Lexington District of Probation and Parole to try to locate her.
Where was that location?
It was at a sober living facility, from what I was made aware of by officers.
And were you able to ascertain how long Miss Crawford may have been staying there?
The complainant said that it was 2 weeks that she had been there at Lexington. I'm not aware of anything else.
And officer, if I heard you correct, on or about that November 9th date, there was a recommendation for outpatient treatment?
She was recommended to do all recommendations from the SSC along with the marijuana education packet in lieu of revocation.
Thank you, officer. Those are all the questions I have.
No redirect, no other witness.
You have any witnesses you'd like to call?
Judge, I would. I'll call Keisha Crawford.
You raise your right hand, man. Swear the testimony about you is the truth. Excuse me, the truth, the whole truth, and nothing but the truth. So
Yes.
you may, yeah, thank you very much. You may-
Thank you, Judge. Keisha, you've heard the testimony. After November of 2022, where did you go?
Well, I was just working and things like that for a while, and then I decided that, I had a drug problem and needed help, so I went to rehab.
When was that?
She froze.
I think she froze.
I don't know. You said my dad was sitting there and something is going on.
It's not a really good sign with the rest of the document. And Derrick County, they hang up and dial it, and get back in. Somebody call Derrick County and tell them that they need to try to get back in.
Yeah.
That's Thomas James. Get back in.
What was in the box?
He was going to play, he was already got some, that was this week. Yeah.
Hey, somebody's got Derrick County Jailer back on there.
They never left, Judge. They turned their camera off.
I understand, but it's,
They said they're trying to get back on, Your Honor.
somebody needs to click them where they are.
Judge, that's not the one that they were on. The one they were on did leave the Zoom room, so they're trying to get back in.
So then take care of it. So then take care of it.
Did you ever ask about that from Opus?
I took it up.
Oh, did you?
Yeah, I done told.
Did you get it from this?
We're back. Sorry about that. We're having internet issues.
Okay,
Yeah.
okay, you want to continue your inquiry?
Yes. So Keisha, I just asked you, where were you at in November of 2022?
November, I don't even remember. Tennessee, I think, is where I went back to.
And I think you were saying you were working and at some point with,
And then I realized that I needed rehab and I went to rehab.
do you remember when you went to rehab?
I went to rehab 4.5 months ago.
Where did you begin rehab at?
Somerset, Kentucky,
And what was the name of that facility?
Lake Cumberland Recovery.
From Lake Cumberland Recovery, did they send you to Lexington?
I went to Lexington, yes.
And we've heard testimony from the officer that this
You need
was
to
so
talk-
related.
Look, you need to talk into the microphone. She can't see you when you're looking over there, okay?
Ms. Crawford, the place in Lexington, was that also rehabilitation?
Yes, sir.
And what was the name of that facility?
Peace and grace.
You can look this way. He's up over here too.
Thank you, Keisha. Your Honor, those are all the questions I have at this time.
What do you have? You have any other witnesses?
No, Judge.
You want to examine her?
No.
What does Commonwealth have to say?
Well, she has a burglary with restitution, and she's been gone for 13 months or 11 months. And I guess if we want to abide by her system, we could eliminate probation, parole, and make everything voluntary. Otherwise, we need to hold her account and revoke her
There'll
probation.
probably some in the General Assembly and go for that.
I might ought to run them sometime. I don't know, but you propose that.
And Judge, I certainly understand the Commonwealth's position on absconding, not trying to excuse Ms. Crawford's conduct. But Judge, what she testified to is.
Okay, she just can't pick her own terms on this. I have no choice but to revoke her probation and hope that she gets some help, maybe get some vocational training and that sort of stuff while she's there. She won't be there that long. So that's my order on this. Thank you very much. I hope things turn around for you, Ms. Crawford. Michael Graves.
Judge, just point of order, was this, I think this was this diversion, Madam Clerk, or was this a?
It says probation application, what it says on mine is the probation of pretrial diversion or probation.
ASAP.
Which one was?
Pretrial diversion.
I just haven't. Well, they say they showed it as a felony up here. I understand what you put on here. Yeah, felony plea.
Yeah.
Okay, Michael Graves.
They're going to grab him. We was told he wasn't gonna be on the docket, so I didn't get him up, but they're gonna go grab him right now.
Okay, let's go on to
I've got everybody else.
Annabelle Harvey, Annabelle Harley. Annabelle Harley, are you Annabelle Harley?
Yes, sir.
This is 22CR0092. Were you born in 1999, Ms. Harley?
Yes, sir.
Your last 4 digits, social security number 3238.
Yes.
You're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, this is a case where Miss Harley pled guilty to possession, got a 3-year sentence here in Kentucky. She was transferred to Tennessee. She got a DUI in Tennessee. She was arrested. And then Tennessee, under the interstate compact system, made Kentucky take her back for supervision. So we've got to go forward with our motion to revoke pretrial diversion, but because of that. Now, the DUI is still pending in Tennessee.
Correct, Your Honor. And Your Honor, I have furnished unto the, I furnished to the Commonwealth an update of the case in Putnam County that I received from her attorney there, Mr. Knight. Her next court date is, I believe it's January 17th. There is blood work pending. To refresh the court's memory, Miss Harley was the victim of a domestic assault, fairly severe. Admittedly consumed some alcohol thereafter at a restaurant and was stopped and arrested for DUI.
Yeah, and this is the case, court recalls Mr. Cross called you on, was wanting to get her out of jail, and then you learned from the police officer, and then in the probation report, she alleged to have hit the car or whatever while she was.
She allegedly hit, according to the citation, she hit the window of the cruiser 3 times. He did not charge her with anything, and considering the kind of day she'd had, it's not permissible, but it's understandable. And what I'm going to propose to the court, Your Honor, on her behalf is as follows. She's not been convicted. We don't know what's going to happen. I would move to allow her to be released on home incarceration.
Where does she live?
Putnam County.
I can't supervise her down there. We can't supervise her down there.
But we can,
Tennessee sent her back.
we can put her on home incarceration.
Tennessee sent her back up here. They're not going to continue under the interstate compact to supervise her.
Your Honor, if she's on home incarceration.
I can't put her in home incarceration.
Why not? We done it, we put him in, had Tennessee people before. I don't understand.
Well, you can put her on home incarceration, she just won't be supervised.
Right.
That's what you want. But
Yeah.
I think that's where you and the judges have
I don't
different.
know whether I've ever put anybody in Tennessee on ankle bracelet and home incarceration.
Your Honor, we've had it done before. We've had people on the bracelet down there.
I just don't think this is a good idea. I mean, she had the DUI charge and then she was taken into custody and damaged their police vehicle and kicked it and stuff. I don't know. It doesn't seem to seem like.
It didn't say there's any damage. It just said that she hit the window 3 times. So as I say,
Well, if
the day she'd had, I can understand it.
I can try to get the officer up here and have a hearing, if you want to do that. Or we can wait on the
Have you
DUI.
talked to the officer down there?
No, I tried to call and sometimes you can get a hold of somebody and sometimes you can't. I can try again.
We try to get police. Sometimes they're hard to get a hold of.
Well, we'll schedule her for January the 25th.
Your Honor, I know her father's here. He's traveled from North Carolina. If we could make.
He traveled from North Carolina before. Last time without anything, he traveled from North Carolina before. I'm sorry he traveled from North Carolina. That doesn't change her circumstances.
No, if the court would allow me to.
I'm finished with this case, okay? She'll be back here on January the 25th. Thank you. Todd Howard. Commonwealth versus Todd Howard. 23 CR 0099. Are you Todd Howard?
Yes, sir.
You born in 1985?
Sir.
The last 4 digits associate your social security number 9931.
Yes, sir.
Okay, we're here on 23 CR 00099. Says that we are here on a pretrial conference. Y'all have a plea agreement?
We do, Judge.
Is it a diversion or a felony plea?
Diversion, Your Honor.
Motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently on the influence of drugs or alcohol?
No.
This plea freely and voluntarily given.
Yes, sir.
Are you the same person named in the indictment that I read?
Yes, sir.
Judgment impaired today in any ways?
No, sir.
Have you discussed the charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you?
Yes, sir.
Do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky United States Constitution. You have the right not to testify against yourself. No one can make you say anything. You have the right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, call and testify. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter out of court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Understand that in the plea today, you give up all this rights. You understand that?
Yes, sir.
Consider the Commonwealth's recommendation, but keep it there for just for a second. Okay. But may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Now, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances. Second offense, the defendant shall pay a fine of $300 plus court costs at the discretion of the court and serve 7 days in jail. Defendant agrees to be assessed by the social services clinician and will follow any recommendations. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. Defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that your understanding, sir, of the Commonwealth's recommendation?
Yes, sir.
Previously been diverted in the last 5 years?
Yes, sir.
Where were you diverted?
No, sir, I'm sorry.
Okay. You had any felonies in the past 10 years?
No, sir.
Currently on probation or parole?
No, sir.
You understand if you completely complete this diversion, the charges will be dismissed, pretrial diverted, you can have your record expunged. However, if you violate the terms of this agreement, be brought back in front of the court. If I void your pretrial diversion, I'll have a pre-sentence investigation for it. Then you'll be a convicted felon that can be used against you in the future. You understand that?
Yes, sir.
Pleading guilty because you did commit the acts charged in the amended indictment.
Yes, sir.
And knowing your constitutional rights to explain still your desire to enter a plea to allow the court to fix your punishment. Okay,
Yes, sir.
I'm gonna show you a signature on here, sir. See if that's your signature. Is that your signature on there?
Sir.
Okay, thank you. I'll accept the plea and sign the diversion. What are the court costs on this thing? Is there a DUI?
And Judge, that's what I was about
And
to
I'm gonna
say.
ask you on the DUI, you realize that because you entered a plea of a DUI, that's enhanceable in the future also. You understand that? If you get another DUI, it can be enhanced.
Yes, sir.
Okay, well, you have $900 and something dollars. When do you pay that?
Give me, I don't know, sir, a couple months at least.
Okay, well, I'm gonna tell you what I'm gonna do. I'm gonna allow you to pay $100 a month on it. The first payment's due 30 days from today. Okay? Mr. Stockton, he's getting out today. Is that correct?
Yeah.
Yeah, you'll need to meet with probation and parole. When will y'all see people?
Tomorrow morning, Your Honor.
Well, why don't you, I'm gonna let you out in the morning. And you just go over to the probation and parole officer, the office over there. What time?
9 a.m. is fine. Your Honor.
9 a.m., okay? So you get out first thing in the morning, you go over to probation and parole.
Thank you, Judge.
Okay. Ms.
I got Mr. Graves up here if you want to do him.
Okay. That's Todd Howard there, correct?
Yes.
Okay, let's go back and do, Michael Graves.
Yes, sir.
Commonwealth versus Michael Graves. 23 CR 0060, you are Michael Graves. Correct? You were born in 1972.
Yes, sir. Correct.
4-digit social security number 9793. We're here on pretrial diversion revocation. What does the Commonwealth have to say?
Well, Your Honor, he had a positive meth test, was referred to
Speak up
that.
just a little.
He had a positive meth test, was referred to the SSC, went to rehab, had to restart, then he left and was picked up in Florida. So I don't know if he wants to stipulate or not. But he had to be extradited from Florida in this case.
Your Honor, here's where we are with Mr. Graves. He has taken an unauthorized vacation, we'll call it a filibuster in Florida. They only brought him back, I believe, Wednesday. He's not going anywhere, and he may have another charge here. I would move to pass the hearing until the 25th, where I can meet with Mr. Graves and with Mr. Stockton and see if we can get a global resolution of whatever he's got.
Does he have another charge here?
We had several grand jury cases. I can't remember.
Mr. Cross seems to be aware of what the grand jury.
Yeah.
It's not on the list.
Yeah, I think he took his dad's truck to Florida, and I don't know if his dad wants to even press charges on it or not. It's not one that I would be keen to prosecute since it's family.
He's
Because
apparently
they tend to change their minds in cases like that.
He's facing a criminal charge in Florida in that regard. If he's going to have to deal with something, I hope we can just deal with it up here.
Well, I mean,
We don't have a case, so.
tells you they're not gonna deal with it up here. So.
Well,
You can't enter a guilty plea when a Commonwealth doesn't charge you.
well, Your Honor,
This is the
between,
first impression that I've ever seen.
but no, Your
That you
Honor,
wanted to
between
enter a
now,
guilty plea for somebody.
between now and January 25th, we might want to do an information on it and get it all resolved and call Florida and say, we'll deal with
Well, I
the
can
graves
put
up
off,
here.
I can put off, sentencing if that's the case then, but I'm gonna have to do what, avoid his pretrial diversion because he absconded. And then we will order precincts investigate and sentencing, on the 25th, okay?
Thank you, Your Honor.
Thank you very much. Mr. Cross will be up to see you, sir.
Pardon, sir?
I told him you'd be up to see him
Yes.
about the discussion here, I assume. Kenny Huddleston, is that correct? Kenny Huddleston.
Go back on the 25th.
25th. Kenny Huddleston. Commonwealth versus Kenny Huddleston. 18 CR 0016. Are you Kenny Huddleston? You're here on a probation revocation. You were born in 1990, Mr. Huddleston.
Yes, sir.
Last four digits, social security number 9589, correct? It was Commonwealth have.
Your Honor, this is his second motion to revoke probation. He had marijuana test, positive for meth. He was terminated from South IOP and he went to long-term treatment, completed that. But now he's got a new felony fleeing and evading that went to the grand jury this morning. So if the court wants to set a time where we can try to wrap all of it up, I'd be glad.
Now let's set him for a negotiation day on the 19th of January and the next court date on January 25th. Mr. Huddleston, they said there was a case that had gone through the grand jury. Is that it? And today you were indicted. So what they're going to do is your attorney will be up and talk to you about that case. So you can wrap all this stuff up. Maybe you can do one day. So he'll be up there. Okay. Thank you. Jameson Malum. Jameson Malum. Commonwealth versus Jameson Malum, 23 CR 0092 and 23 CR 00107. Are you Jameson Malum?
Yes, Your Honor.
We're here for a pretrial conference on these two cases. You born in 2003, did I say?
Yes, sir.
What does the Commonwealth have?
Felony plea, Your Honor.
Okay. Mr. Malum, a motion's been tendered, says you wish to enter guilty plea today. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol.
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 0092 and 23 CR 00107?
Yes, Your Honor.
Judgment impaired today in any way? Is your judgment impaired? You know what's going on here?
Yeah.
Okay. Are you the same person, have you had plenty of time to discuss this matter with your attorney and are satisfied with his advice?
Yes, sir.
Okay. Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed?
Yes, sir.
Understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to. Never, I'm gonna go over your rights at the end. I'm gonna ask you if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything right to speak trial by jury. You have to be represented by counsel at your jury trial. the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering your plea of guilty, you give up all those rights. You understand that?
Yes, Your Honor.
It says the Commonwealth's recommendation that I may apply a range of sentences. What, allowed by law. Prior to entering, prior to accepting the recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I decide to give you a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Upon a plea of guilty to trafficking in a synthetic drug, the defendant shall receive a sentence of 1 year. The defendant stipulates to Cumberland indictment number 23 CR 107. Thus, the 1 year sentence shall run consecutively with Cumberland indictment number 23 CR 107 for a total of 6 years to serve. The defendant shall forfeit $2,330 to the Commonwealth and it be dispersed in accordance with said forfeiture order submitted with this plea. Defendant shall receive credit for time served. The defendant agrees to have any and all evidence forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes, Your Honor.
Was there, I believe in this case, did that 2,300 include the finding of how much he would profit on the synthetic drug?
What's that?
The money that is forfeited, is that what he was profited?
That was the money that was seized.
I know, but they're in their synthetic drug law, and there a situation where a person can be fined or forfeited the amount of money, twice the amount of money that they were going to receive.
It's $2,000 in 3 days.
It's
And then $2,000 in 3 days.
Yeah, we could have added additional, but I satisfied.
He's asking, well, who profited from he sold this drug? He said in the report, they found $2,000 and so that's. So it's.
I see.
It's different amounts.
Yeah, that's correct.
There's an addition, but I don't think what you said.
Okay, this case was transferred down here from Clinton County.
One of them, yes.
One of them, and he's never been sentenced on that case. That
We realized once he entered the plea in Clayton County and then it got transferred here and there was never a sentencing done.
Oh, okay, so we need to do that too.
well, he's got a PSI on that. So what we can do?
That's why I was gonna ask if we could waive,
No,
PSI.
I'm not.
Well,
I'm
for-
gonna tell you what we're gonna do.
Yes, Judge.
We can supplement the PSI and sentence him next month.
That's fine. And he made a statement to the officer that he had made approximately $2,000 in 3 days selling the synthetic drug. So that was the basis for the forfeiture.
Yeah, but you can get up to $4,000, correct? Get twice the amount, that's what the statute says.
But he's going to prison, I wasn't gonna make him pay it.
Okay, well, I'm just trying to see what the $2,000 was.
Yeah.
So you made the prosecutorial, within your prosecutorial discretion, that the $2,000 could be identified as money that he made, and that's your forfeited. I just thought the forfeiture might go to different places under that statute than it does money that you confiscated.
It's divided differently. I
It's-
think it's divided equally.
Yeah,
50-50 is what it says.
yeah. We'll fix that in order whenever his final sentence.
Okay.
Yeah.
Just long, so we'll have him here on the 25th for final sentence.
Yeah, and there's some, I know what Ms. Thompson referred to, and then Ms. Beaver Ms. Thacker had a discussion on that. I think it's the fine can be this, is rather.
Well, you'll need to delineate which one of those you're electing under because it has a impact on how it's distributed.
Okay, we'll do that. Sorry.
Let's show him his signature. Give me that document there.
Judge, Madam Clerk, had
Mr. Malm, is that your signature on there?
Yes, sir.
Thank you. We'll see you then on the 25th and we'll look at these. I'll take a look at these other forfeiture documents and that sort of thing.
Appreciate it.
Thank you. Kenneth Neal. Kenneth Neal. Commonwealth of Kentucky versus Kenneth Neal, 23 CR 0025. Are you Kenneth Neal?
Yes.
You born in 1978.
Yes.
Last four digits of social security number 4427.
Yes, that's it.
Okay, we're here on 23 CR 0025 at pretrial conference.
Your Honor, he has a trafficking case in Wayne County. I need to confer with Mr. Leverage. He has two possession cases here, trafficking in Wayne County. And I want to confer with Mr. Leverage to see what the total package would be.
What we will do then is have him on the 25th of January. Do you want a conference?
If we could, Judge, his pretrial conference in Wayne County is January 9th, so he should have clarity
Okay,
on
so
that.
you meet on a negotiation day on January 19th. Next trial date on January 25th. What they're trying to do, Mr. Neal, is roll your stuff up in Wayne County and this together, okay?
Yes, sir.
Okay, thank you very much.
Thank you.
We got Thomas O'Donnell on the docket. You are Thomas O'Donnell,
Yes.
born in 1961. Last four, number 6773. We're on
Yes.
PR 00103, and it says arraignment.
Oh,
was there superseding or an amended indictment?
There was a superseding indictment.
We have not received a copy of that, Your Honor. I thought we would receive it this morning.
Well, you will, you're about to, just a second.
Thank you.
I think they've already been done. It's already been done.
Please sit there.
Oh.
Oh, the grand jury, Mr. Donald, grand jury of Cumberland County has returned an indictment charging with capital murder, aggravating circumstances. Is that right?
Yes.
And is this a superseding or an indictment, or how you gonna?
It's a superseding indictment, Your Honor.
Okay, and were there other charges that were you're using the same number?
Yes.
Were there other charges besides this?
No.
So
Your Honor.
this is the only, now this is, Mr. Bailiff, you hand it. Counselor, you acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment. Enter plea of not guilty, reserving all pretrial motions on that.
Yes, Your Honor.
Okay, now we also have on the docket, motion to suppress, a motion to set for trial, and a motion for evidentiary hearing, and then an ex parte motion.
Yeah,
Correct?
and there's also a motion to exclude evidence. Should have been on there too.
That's correct.
Okay, which one of these you want to hear first?
Your Honor, I think the Commonwealth filed a motion to set these for evidentiary hearings so that we can call witnesses.
That's correct, Your Honor. I've read through their motions and I probably have a different opinion on some of the facts. So I believe I'll have to have an FBI agent, KSP, and maybe the lab examiner here. So probably a day. And then we've got a hearing on the suppression statement. That's going to take a little bit of time. So I'd ask for at least a half a
Those on
day.
the next rule day? Or you
I don't
it'll
think we
take
can
more?
do it on a little day.
Okay, well, let's pick a date here, and then Mr. O'Donnell will need to be on issues like this, he'll need to be present.
Yes.
So we'll need to have a transport order. Let me look at my calendar.
And Your Honor, I'd like to inform the court with a caveat. I'll have to make sure the witnesses are available.
Oh, I understand that. Well, let me just do this.
Yeah.
Let me, you get that information and contact the defense counsel. And then y'all call me on a conference call and we might be able to set it sooner rather than later that way. And if that's okay with all of you to do that.
Yeah.
And I'll be available. You call my chambers and we, even if I'm not there, my staff lawyer has the calendar, we can set something. Now, that would take care of the motion to suppress an evidentiary hearing. And then
Motion to exclude.
Motion to exclude. And then we'll do an ex parte motion in a few minutes. And then we can't set it for trial until these other things are taken care of.
The only reason I filed the motion said trial date when we set Whitledge, because of their schedule, we had to go out into September. And I didn't want to get too far down the line.
Yeah. Okay. Well, we can do that, and y'all need to, depending upon what the evidence is or what they need to develop. I don't know what their ex parte motion is about, so it could be, take time for development, it could be, once they put you on notice, if they develop anything, you could need additional payment. You know, okay. Okay, if y'all wait around to the end of the docket, we'll go downstairs in the chamber. Madam Clerk, can you prepare that chamber down there for us to do the ex parte?
Downstairs.
Downstairs,
Okay.
we'll do that in just a minute, okay?
Thank you.
Thank you very much. Janessa Smith. Janessa Smith.
Yes.
Commonwealth versus Janessa Smith. 23 CR 006. Are you Janessa Smith? You born in
Yes, sir.
1999?
Yes, sir.
Last four digits of your social security, 1768.
Yes, sir.
What do we have? What does the Commonwealth have?
Yeah, this is kind of Mr. Huddleston. Mr. Kenny Huddleston is the alleged victim in this case. And he's been on the run. He's currently incarcerated. We called his case earlier this morning. And so I would ask that this case be set for January 25th. So I'll need to know if I need to get a special prosecutor on one of these cases or if I'm going to proceed on this case.
Okay, so there's no reason to have a negotiation.
No.
What's she charged with?
She's charged with stealing a four-wheeler or joyriding with a four-wheeler.
And Judge, I don't know if Mr. Huddleston's still in the room, but it's my understanding that he is not going to wishing to proceed against her.
If he wants it dismissed, I'll agree to dismiss. Because
Well, you need to get a written statement from Mr. Huddleston, sent to Commonwealth Attorney's Office. And y'all can do it by agreed order if he doesn't want to proceed with it.
yeah, but I've never been able to contact him. In fact, I'd had subpoenas out for him to try to get him to court. So,
They'll be in contact with you, Ms. Smith. If it's not dismissed by agreement, you'll be back here on January 25th, okay?
Hey, sir, so I got to stay in jail? Or can I just plea out to it and go home? Cause I really want to get home for Christmas.
Plead out to it yet, cause it might be dismissed. So what? You know what? For what?
So,
Wait just a second.
yes, sir. Cause they're waiting on him to sign papers. That's gonna take a minute.
She's got another indictment for today. Your attorney will be up to talk to you about this, okay?
All right, sir. Thank you.
Donovan Waller. Oops. Donovan Waller.
Judge, he's actually at the Class D facility, so I don't know that he's.
Is Donovan Waller on the line there? He's at the Class D facility, they say.
I can get him on there.
Okay, and get Cody Willis while we're waiting for Donovan Waller, okay?
Okay, I got him right here.
Commonwealth versus Cody Willis.
Hey, please. Have fun.
Are you Cody Willis?
Yes, sir.
This is 23 CR 0040. Mr. Willis, you're born in 1989.
Yes, sir.
Four-digit social security number 2394. This
Yes,
is
sir.
a conference on motion to revoke bond. What's the Commonwealth have on this?
trial date, Your Honor. He's the one that turned himself in after we had the last trial date. He was on,
Hey, y'all need to get on.
we had it set for trial. The victim's from Colorado. He had absconded and his arrest warrant out. And he waited till after the trial date and turned himself in. So we didn't have a trial date.
Okay. How long will it take?
I'd think a day.
Day.
You might want to know. Okay.
We need to take a look at a contempt motion on the next day we do too. Schedule a contempt motion on January 25th. And then let's look at, what about January the 26th? It's a Friday.
I think that'd be all right with the Commonwealth.
Just a second, Judge.
That'd be, they needed to get on and let them know.
That cover girls. That's what it's something to do. That might be about ready for people that don't even do it.
Judge, I have a
Foster case.
trial in Madison County that day.
He's not gonna move it.
What about the 9th of February?
That's fine with Commonwealth.
Is that a negotiating day?
It is. Yeah, I've never gotten. Yeah, we just won't have a Monroe negotiation day. Well, that's the one, we'll have to get another date for that.
February, that's not okay.
No, we'll do it. We'll just get another date for the negotiation day for Monroe. We might do it on the 2nd.
So, yeah, Judge, so along with that movement,
Hey, what motion?
It's gonna be told on that.
And what about the motion to revoke his bond?
I'm not gonna pursue it. He's in custody,
Okay.
so.
Okay, we'll have a trial then on
for the
February 9th.
contempt next, the 25th, Judge.
Contempt on the 25th, yeah. Okay, thank you.
Your Honor.
Now, Donovan Waller,
Your Honor,
yes.
I was going to say if, be granted permission to go to my grandfather's funeral. He died the day before yesterday
Where is that funeral?
in Cumberland County. He at, North New, I think, is where they're having it.
Thomas J., can you make arrangement to transport him down to the funeral? Okay, we'll make arrangements, sign an order for the jailer to transport you down there, and you need to tell your family to contact the jailer to make some arrangement for you to have a change of clothes brought up to the jail where you can change clothes. Before you go, I want you to go down there. Prison outfit, okay?
Thank you, Judge.
Now we have Donovan Waller. It's the last one, I think. Is that your Class D
That
facility?
may be the Adair County RCC.
I think they're trying to get on.
Okay. Ah. What do we have Donovan Waller on?
A plea, Your Honor.
But we don't know that. That's just what we've seen. It could be somebody, some other.
It's showing they're not connected to audio, so I don't think they can hear us.
You'll meet Could the jail call out there to Class D facility and say that there they are? Can y'all hear us?
Yeah, that's
Yeah, but now.
Y'all can hear us now? Can you hear me? The microphone is clicked off.
I got his number.
There's a little icon there that looks like a microphone. You need to push it. Okay, can you hear me now?
Yes.
Commonwealth Kentucky University.
He went out to work this morning and his lawyer come by and his lawyer come to see him today and told him that he wasn't to be in court today. So we sent him out to work.
Where is Donovan Waller?
He's out to work on the work detail.
Okay, he's not there today, so put it off to January 25th. Okay, tell him that
Or sooner, Judge, and I'll
we
be
scheduled for January 25th. Tell him his lawyer will be in contact with him, okay?
Yes, sir.
Okay, thank you. Y'all are excused.
Thank you, sir.
Okay, that finished the lovely criminal docket. We had a pleasant experience.
Merry Christmas after that.
Merry Christmas to all. We are blessed. We got this girl here.
I'm coming back for jury.
I'm going to.
Now, what's next for
We going downstairs on the dog.
we got an ex parte, going downstairs for. What else?
Show cause.
Show cause docket. Anthony Garrett owes $2,020 in 13 CR 0039. Since how long? Okay, well, tell him to pay $400 by January 15th. By January 25th, or let's make it January 15th, $400, and then pick up the $100 payments, okay? Christopher Slavey. It says last payment August 31st. Enter show cause warrant why he should not pay the entire amount, $495. Mitchell York. You what?
He's in jail about 3 months.
Yeah. Tell him to pay $100 by January 15th. Is there anybody else? Is that it? Okay, we will go downstairs to hear the motion.
So she's staying or?
Oh.
If you think about it, downstairs, just.
Yes. Just outside of the door. Just outside of the
Just because she's. And then we don't have to come back and we're home. Okay. And we don't need to be back up here.
You gotta be back up here.
You wanna come around here?
I tell you what. Well, yeah, I mean, that's fine. Well, something like that's fine. If you're gonna run everybody out, if you're gonna be here, there's no use in them getting run out, that's fine. We'll keep one up there.
I've got a load out there. Oh, you gonna get it?
I need to call you and get those dates.
Actually, even though,
Yeah.
no, it was scheduled 11, we're just not. We're as soon as we can.
I'm sorry, I can't be responsible for it.
We'll be different.
Okay. Yeah, like get down, doctor's office here.
And then we'll put it straight, actually said.
Every year, it was something.
A mayor was in Monroe County, the Clinton County, where that's Rodriguez.
Yeah, it was something, Riviera Rodriguez.
Yes, Kelvin Rodriguez.
Oh, we don't need to do anything. President PSI, I mean.
You've got the plate. I think, did he give it to Jason? I think like Jason, but Jason has it. I could email you the copy, but it's not signed. Okay.
It's just to get Bethany started.
I can go back there. I got it in my email. I'll just send it to you.
Okay, Senator.
And I'll see. Okay, yes.
Good.
She don't need that stuff.
I'm sure Christine will love it.
She gonna be inside. As if she would be.
Yeah.
You got anything else? Oh,
Yeah, you wouldn't.
well, no, I need to go over this. That's what you say.
Well, I may have guessed.
Is she going to like? I need you to come around here when you get done. Okay.
You already know all that. You already told Megan about the request for interviews.
Yes.
How much older? She said we love it. We want to do this all the time. No.
I'm gonna do it tomorrow and then she can have it back.
Well, you got it. I think that hard. What do you think she did?
Okay, we have a motion for temporary visitation and for a final hearing, is that correct?
Correct, Your Honor. Or like your counsel first.
Yeah.
May it please the court, Your Honor. The motion that we filed back in October set forth somewhat of a chronology about this case. We have done everything counsel can do to try to work out some sort of an agreement. Mr. Mitchell, who's present with his mother and aunt, everybody understands that anything, any sort of contact he has will initially need to be supervised and will have to be graduated because it's been several years since he's seen the children. However, he has been fighting to try to see them for well over 3 years. They initially filed a proceeding in Pickett County. He first came to office in September of 2020.
I don't want to get down how
Right.
many times he came to your office or anything. Well, wait just a second. Are there exceptions in this case? Or is this just a motion?
No, this is,
It hadn't been in front of the commissioner at all.
it has not. And
I had another case I read last night, had been in front of the commissioner and I kind of got him.
What,
Is that your case been in front of the commissioner?
That is fine.
Okay.
what the court had stated back,
I don't want you to tell me anymore what I've
Okay.
stated anytime. You tell me what I stated all the time. I don't remember what I stated. If it's not in an order, it doesn't matter what I stated, okay? Let's just get down. What kind of visitation are we talking about now that you?
Your Honor, we just like to have a few hours supervised by my client's mother initially for a couple of months on occasion, and then we can see how that goes.
Okay, now,
Yeah.
you get behind the podium.
And she has concerns about this. She's prepared to testify to some brutal domestic violence that's taken place, one involving the minor child, one of the minor children being face forward on a couch. I mean, there's been physical injuries sustained.
Were there charges filed in this?
There have not been charges.
How long ago did this happen?
In 2016 is when those incidents happened, and that's what instigated her leaving the home. And then he's been incarcerated and various things have happened. What she had proposed was for him, if contact would begin immediately. Obviously, the children they don't know who he is. So she wanted.
What has she proposed to?
She has proposed for him to seek some treatment, domestic violence, like a batterer's intervention program, that type of thing. And also for it to be in a therapeutic setting, because a therapist would best be trained to know how to attain to the children's needs, to address the children's needs with not ever seeing this individual. And it would be supervised that way. And then also he could be receiving some ongoing treatment for the problems, because this domestic violence was not just with her. He has a history before her and after her. So it's a pattern, and it affected her young children, and she's prepared to testify and tell the court about that today. But she would agree to, he would do the batterer's intervention and it be in a therapeutic setting. I think she also had maybe asked for a mental health evaluation, something of that nature, but she understands that this may have to happen, but she just thinks there's certain safeguards that need to be in place. Rather than just throwing the children, they don't know who he is. And the last time she was around him, she was terribly beaten, and she can tell more about it, but one of the children ended up face forward, an infant on the couch, so.
If I may respond, Your Honor. He's done anger management. He's done various classes over the years since this has been pending. Ms. Hundley wants to talk about the children being afraid of him. It poses a question. What have they been told? What have they been told? We don't know. The last thing we want to do is throw them into a situation where it's hard on them. But the longer it goes, the worse it is. And we realize we've got to crawl before we can walk.
You could suggest for this sort of thing. You can get behind the podium.
Yeah, just any therapist. I mean, I think we looked at, we had some at mediation that we kind of proposed, just somewhere that would be in Clinton County. I think that would work. for them, to do. What was it, quiz counseling? I think that we
You have to go around that way.
Did you give him Stacy? Yeah. Okay.
Yeah, crowds go on over here. It's pretty
So you are. How are you? Understand. I don't know.
That's the lunch. So really small these folks, just give them every final set of all. It was a song, it won't have money on me. Okay, thank you. Okay. I'm good. Thank you.
I've got some kind of, I was listening on some kind of case.
Was the municipal insurance company versus Fletcher excavation? You may have just stood in for another attorney, let me get it. It's a possibility that those out of town attorneys may have got you in on it or something. Yeah. It was transferred here. That's Ken Judd, and that's Ken Judd, that's how he heard today. Just come out to tell you.
Had my name on that. Oh, well, anymore, I don't even think things, what they hear for that.
Yeah, I got an email from Ken. He didn't receive notice of the motion, so they're gonna re-notice.
Okay, thanks so much.
Child supports, child support docket. No. Severe versus severe.
Judge, I've got a contempt order to tender, asking that, Mr. Severe be held in contempt, that he may purge himself of contempt by paying $600 on or before February 28th and asking it to be reviewed on that February date.
Okay. Shelton versus Shelton.
Judge, another contempt order, current arrearage in the amount of $1,599.62, asking that Mr. Shelton be held in contempt and that he be permitted to purge himself of that contempt by paying $500 on or before February 28th, and that matter be reviewed again on that following day in February.
Sites versus Calgill.
Respondent is paying in this one, Judge. We're just asking that it be reviewed on the June date, June 27th.
Cooper versus Cooper.
Respondent is paying there, Judge. We're just asking that be reviewed on the 13th day of March, 2024.
Thank you.
March 6th, the 19th, that change.
Yeah, that got changed to the March the 19th.
Okay,
So I'll just go put.
that's fine. Thank you, Judge.
Delineate that. Hope Springs Eternal, that the NCAA tournament will go differently than it has in the last few years.
Don't jinx it.
Hill versus Haywood.
Judge, another contempt order. There's an arrearage, asking for an order of contempt, but also that he be allowed to purge himself of that by paying $500 on or before February 28th to be reviewed that following day in February.
Okay. Thank you. Is that it?
So that's all I have, Judge.
Okay, thank you so much.
Thank you very much for the excuse.
Yeah, Merry Christmas.
Thanks, Mayor.
Adair Circuit Court, meeting in special session. Are you doing Adair Circuit Court?
The Dean versus Sparks?
Yes.
Yes, I am. I'm Jennifer. Nice to see you. I hadn't seen you in 6 years or more.
Yeah. So who are you representing?
I'm representing Miss Johnson. Miss Dean, now Johnson.
This is Dean versus Sparks. Correct?
It is,
What do you
Judge.
have?
I have filed a motion asking that we transfer venue to Pulaski County. Miss Johnson and the child have been there for about 4 years now. So we believe it to be a more convenient forum for adjudication of issues. It's our intention to file motions in this action as well as a possible termination action. And given that's the county where the child resides, we must file it there. So we're asking for a transfer.
So Miss Dean is now Miss Johnson.
Correct, yes.
Okay, is Mr. Sparks here? Mr. Sparks is not here. Did you give Mr. Sparks a notice?
I did, Judge, and in fact, I mean, not to overstate, but he called my office twice, once yesterday and once on Monday, making some pretty egregious statements to me about my appearance here. So I'm absolutely shocked he's not here. The statements were such that I even went so far as to ask my husband to come with me. So
Well, it's always nice to get to come to Cumberland County.
you know what? I had a fabulous lunch at the cafe over here. So yeah, that
We'll
strawberry
leave more
salad.
money here. I hate to lose a case like this, to transfer it to someone else, but begrudgingly, I'll do that.
Thanks.
Megan,
Yes,
hello?
it's not scheduled until we.
Okay, says this is not scheduled to 1:15, so I have to wait.
Mr. Sparks is bringing his own house.
What kind of motions, Mr. Sparks?
They're
No.
right there in front of you.
Okay. It's my staff log.
Oh, okay. Well, if you want
Wait just a
to
second.
recall it at
Wait just a
1:15.
second.
Oh, okay.
Did he serve you with a motion?
No, about 2, 3 weeks ago, give or take, the child support office advised Ms. Johnson that he had filed a pro se motion. And she came in and obtained a copy.
He claims he mailed it to her at 7852 Liberty Road, Columbia, Kentucky.
She says that she never received it, but we did get a copy from from downstairs once the child support office told her that something had been filed.
I'll see if he shows up.
Of course. Hey, I'm doing well. How are you?
Are the parties here in West Bend Mutual Insurance Company versus Fletcher Excavation?
Judge Mike Fansickle for Plains of West Bend. Harlan Judd represents the defendants. I've spoken with Mr. Judd today. He's not able to make it, and he did not, I guess he didn't receive notice, what he said, of our motion. I sent that to him today, and we agreed on getting another date for it, maybe putting it out a couple months, Judge. Is that?
This motion to get a judgment on the pleadings.
Yes, Your Honor.
I wish I'd known that. I wouldn't have read all that stuff last night.
Sorry.
It's okay. When you just notice it when you want to.
Okay, I'll file a renotice.
Yeah, I hadn't thought about that kind of things about indemnification for a while, so it's good. Okay, what our rule days, we got one rule day on January the 25th, which is, but it's changed a little bit on the normal day. Then we got one on February the 29th and March 19th. Okay?
Thank you, Your Honor.
Okay.
Any excuse?
Sure. Merry Christmas.
Merry Christmas to you.
At your convenience, Your Honor.
Well, we've got a little time here before we start on our 115 documents here that we've got.
We can do the therapy at the community-based interventions in Albany. My client also found she's still requesting that he do the batter's intervention program.
I don't know what that is.
It's an 8-week course to address domestic
Well, let
violence.
me tell you what, let's see how it goes with these interviews here with us, these first set of things.
Yeah, I'm not sure that that's going to address, I mean, I would ask for you to hear her testimony, to have a hearing, to hear her testimony of in depth. I mean, it's severe domestic violence. I mean, I wouldn't just tell you that she's not trying to just withhold a child. I think there just needs to be something intensive to address those issues. And we're just asking for him to do that. And it can happen at the same time as this therapy is going on, but just something to address that. She also is asking for a psychological evaluation and a hair follicle drug screen. I mean, the proof
So
will
we haven't
show.
accomplished anything really.
What we have, Your Honor, here's where we are, if you're through this out. Your Honor, we're in agreement. We're following the lead and the directive of the court. Community-based interventions for therapeutic visitation initially is fine. Whatever the court or the therapist deems appropriate is how we'll proceed. Now, this other stuff, he's done 2 different programs. This stuff happened years and years ago, and we are not in agreement to do that unless it's ordered by you. And I think it's absolutely, completely unrealistic. And Your Honor, that Ms. Hunley and the prior counsel have done a heck of a good job putting this thing off. We have been over backwards with mediations. We're good on the therapeutic visits. He'll take a hair follicle test today. That's fine about that, but I think we have done well. You said proceed with the therapist, and that's what we've agreed to do. I don't think anything else is necessary.
But the therapist is not going to make recommendations. I mean, if they're not agreeable to do address all of the issues, I mean, the therapist is going to address the children and their ability to reunify with their father. We also need to address the domestic violence issue. And so then our position would be a custodial evaluation would be needed. We were just trying to kind of short circuit that because those are things we anticipate that would be recommended. I'm not a custodial evaluator, but those are the type of things we think would be recommended under these circumstances. So we were trying to come up with a plan to address that. And so if they wouldn't be willing to do that, our proposal would be to go to a Dr. Evans or Dr. Feinberg in Lexington, let them meet with everyone and then make a professional assessment of what needs to happen. If they don't want to follow the plan that we've requested.
Your Honor, I'm glad you're deciding this case because we're going to let Ms. Hunley and her client will never get a darn thing. Thank you.
But I mean, that's all we're asking was just to start that we're willing to start therapeutic visits
We're
now.
talking about something that happened 7 years ago.
Well,
Is that right?
Well, and it's happened as recently as a year ago. And I believe we had his ex-girlfriend that would also come and testify that there's been domestic violence. And then the person before her. I mean, you know, we don't have proof that these things have been addressed. These are her very, very young children that do not know him. You know, a 3-month-old child was laying over on a couch. I mean, it's a serious situation. And
Well, you said it happened 7 years ago. And how old are the children?
I'm sorry, they are, well, the one was
How old
3
are the
months
children now?
now, 7 and 8 now.
Well, one of them hadn't been born then.
That's correct. She was pregnant whenever he did this as
Okay,
well.
and then one of them was 1 year old, so that neither one of the children remember that.
All they know, Your Honor, is what they've been told.
It's not, she's not told him about any of these things. But again, I mean, we'd have her testify and tell you about those, and that's what we were prepared to do today. I think she's entitled to a hearing on those things. Tell the court, and we're prepared to do that.
She's not gonna get a hearing today on it, because I've got a complete docket.
I understand.
What are you doing tomorrow?
I have court in Pulaski tomorrow.
All day or?
Probably till about noon.
Be over here tomorrow. That's 11 o'clock here. Be over here tomorrow at 1 o'clock.
Okay.
It's fine, bro. We'll be here at 1 o'clock.
Because I'm not gonna tear this thing out forever. I'll give, because anytime anybody says domestic violence or anything like that, you know, as lawyers, it triggers something right now, and we need to hear it, because I don't want to pick a paper up the next day and see something's happened. So you'll get a hearing tomorrow. She better have some pretty compelling testimony.
Okay.
Thank you.
Thank you.
Yeah, I'll be here at 1. Okay, Mady Caps versus David Caps.
This is just a review. We have mediation scheduled for next week. And I think you're just reviewing it to make sure we have mediation scheduled, so.
Everybody satisfied? Who's the mediator gonna be?
Bob Young with Helpo.
We'll be fine.
All right, thank you, Your Honor.
Yeah. Justin Wright versus Kendra Scott Wright.
Good morning, afternoon, Your Honor. Do you want me to have my clients also come up, Your Honor?
Okay, what do we have today? We're gonna review this.
Your Honor, you wanted us to come forward to advise you of our efforts to try to get the interviews done. We have run into a major roadblock. Every agency, group, or facility we've contacted either wants, they won't do it because there's not a patient-facility relationship, or they want a lot of money. Which of course Kendra doesn't have and the girls do not have. However, according to DCBS, Ms. Connie Renee Tooley, the Advocacy Center in Russell Springs will do it if you do a specific order telling them to do it, setting the parameters of what you want answered, and then for you to put in that order that the attorneys get a copy of their report. Normally, they do not give the reports to the attorneys, only to the judge. So that's where we're at right now.
There was some other case involving, Mr. Pink, involving a child of your client up here last week or something. Before last, what was that? When there's something.
This has 3 cases into one.
I represent Justin Wright, and I don't really, I haven't talked to the counselors. I think the smallest has done that. Someone that get out of the loop with wrong email address, so I'll just kind of defer to her about the counselor.
And Judge, I've been in contact with you as well. I understand the position that the clinicians are in because to be truly independent, you know, they're asking for a fee in lieu of billing insurance. I can understand the position of put a clinician in to give an independent evaluation to say, for instance, no additional treatment's needed. If they're billing insurance, I think that raises.
Give me a second.
Yes, Judge.
Do you have a judge with the advocacy
Oh, okay. Are y'all in agreement to, y'all do an agreed order?
to the Advocacy Center? Yes, Your Honor. With those provisions set forth.
Yeah.
So that
Are you in agreement with that?
I am, Judge. Just one caveat with that, or one minor point. When we were here last time, Judge, you actually suspended Ms. Wright's phone call, time sharing in its entirety. And I understand we're waiting to get this evaluation, this assessment done. Judge, when we were here last time, the other side had offered two phone calls a month in lieu of the phone. And Judge, we were just asked to go for that. That way the clinician can actually, or whoever's doing the assessment can see if these phone calls would cause any effect.
we never agreed to phone calls, Your Honor. Until you get the independent evaluation. That was the whole purpose. Was to find out what parameters are necessary, Your Honor, for the recontact between Kendra and her daughters. To find out what's best interest of the girls.
Judge,
That's gotta be
White actually
paramount.
did stand right here and say that.
That's gotta be
Say that, Ms.
paramount.
White.
I think when we were negotiating in the back, we did discuss that during the holiday that it was on call, but then,
Judge, it's 4 days before Christmas. Ms. Wright is.
Well, let me tell you, I get a little, you know, I had an ex parte hearing with some public defenders today, and we were down there and we were talking about some things. And after it was over, I talked to some of the attorneys. about these jail visitations that I used to do. And I get a little sappy this time of year when people are in jail and separated from their families and don't get visitation. I have these people who've wrought all these things on everybody down. And then it comes Christmas, they all want to come around and they want to visit and they want to do that, but they don't think of what they've done destructively before that gets them there. And we had a case, and I won't mention it, that was in the judicial system about one of your client's other children, other child that you know about, correct? Okay. And it just makes me think about what a path of destruction that people can establish with children and communities and everything if they act the way your client has acted irresponsibly down through the years. So my sympathy, as I've been thinking about this case since then, my sympathy has grown colder since we were here last time about what I see happening with these children and whether she ought to be reunited with them at all or not. But we do need to get somebody to take a look at this situation, to take a look at if there needs to be a termination situation initiated by someone. That's what you said y'all were going to do. Somebody said that, didn't they?
Judge, I don't
No,
recall hearing
wait,
anything about
no,
that.
sir.
Well, I mean,
Yes.
I'm just thinking that must be
Ceasing
what
the-
you're alluding
ceasing the
to.
Ceasing the visits until the evaluation, and then what parameters to
So
protect
you're
the
not to
little
the point where
girls.
you want to talk about terminating parental rights or anything like that.
We're not there.
I'm just asking you
Yes,
because
sir,
you
we're
were
not
alluding to that, and I thought about all these things that we went through.
Judge, a month ago, we were talking about two phone calls a month. We're nowhere
We're
near
not.
termination. So
You're not near termination. I'm just wanting to know what their end game is, okay? I want to know what their end game is, what their deal is, what would satisfy them, what they think they need to do to protect these children involved. And now they say it's not that, okay? Now we won't go there again, okay?
It's just to protect the little girls and not cause them mental harm.
Well, that's why we're all here. I
Yes.
don't think Mr. Pennington wants to cause me mental harm or anything.
You know, Judge, we're talking about mental harm. If that is the true concern, then these children should be under a condition right now. They should be in active therapy, just like Ms. Wright's other child that you just mentioned. He is in therapy.
I didn't say it was a he or she and don't want to. I don't want, they have a confidentiality situation.
I understand, Judge, but that minor child is in therapy and
I don't want to talk about that. I understand that. I already know all that. Let's do, I mean, if you want to have a private, if we want to go off the record with everybody present, we can talk about that. I'm not prejudging this case by that. I just say that there's a lot been going on down through the years, all I'm saying.
Yes, sir.
Okay, now, do you have somebody, you get me in order,
Yes, sir.
you get me in order,
Yes, sir.
and how quickly can we get that set up over there?
From the information I received from Ms. Tooley, they will act on it as soon as they get your order to
Okay.
get it arranged.
Well, I would make sure that while we've got everybody, we've got all three lawyers here together, you sit down and set the parameters of what should be in that order, so we won't delay it any further. Okay?
Yes, sir.
If y'all go back there and do that, I'll be glad to sign it over.
Judge, one other
Yes.
thing, again, if I need to make a motion, I can. I do believe what we've heard and some of the proffers to the board. I'm going to echo my sentiment that I think a further compelling therapy for these minor children be appropriate.
Well, I'm gonna wait and see
Notwithstanding what
what
this-
this evaluation
See what the
says.
evaluation says. Your
I'm willing to get therapy for them or do supervised phone calls or visitation or whatever it takes to get
Yes,
these children,
Yes,
you know, and I haven't given up on her. I don't give up on anybody,
yes,
you know? I just want everybody to know, including your client, that I will do whatever is necessary to protect those children, and that's what's gonna happen, if it, up to and including termination, if it ever gets that. I hate to do that, but I am capable of doing that because I've done it before, and it kills my soul at the 2 or 3 times I've had to do that. One time I had to leave the bench and was inconsolable Now, if you do anything like that or consider, if you're a judge and even consider doing anything and it doesn't really bother you, ought to quit. So.
Yes.
And Judge, the last matter, and again, if I need to do a separate motion to be heard on it again, but I think while we're here, I think it might be appropriate at this time that the minor children be appointed a joint friend of the court or guardian ad litem.
I don't think that's inappropriate. You know, we can do that.
Thank you, Judge.
Now, you wouldn't object to that, would you?
Well,
Who do you represent?
I represent Connie and Gary White, who
Okay.
have custody of the oldest. Miss Wanda represents Justin, who has full custody of the youngest.
Okay, well, let me get somebody to represent the children, so it won't be
Thank you,
all right.
Judge.
It's all right, you know.
Okay,
Get somebody, not that everybody here, I think, probably thinks they're doing what's in the best interest of children.
yes, sir.
Who's next up on the list?
We'll check downstairs.
Okay, thank you. Okay, well, check with me before you do that, okay? Okay, well, thank y'all. If you
Thank
go
you,
back
Judge.
there and get me an order ready.
Yes, sir.
Mid-South Partners versus NDH Corporation of Kentucky.
Good afternoon, Judge. This is Judd Patterson from Mid-South Capital Partners. It's our motion for summary default and order of sale.
Is this the $90 bill or is that some other county?
Well, you certainly had us tender an affidavit of my fees, Your Honor, which we've done. And I think it was an old one, yes. Unfortunately, we got to do about as much work as a bank foreclosure to get these things done, Your Honor.
How much was the tax lien on this one?
All right, for you right now. Let's see, we have the 2010 tax bill, Your Honor. Which was $640.38 plus interest of $876.80. Administrative fee of 100, pre-litigation fees of $417.76. Then we had the 2011 year bill of $696.27. It's all on the second page of our final judgment, Your Honor. First
Okay,
and second
well,
paragraph.
we'll take it under advisement and take a look at it, okay?
Thank you, Your Honor.
Thank you very much. Make sure Megan gets that file.
Yes.
Jason Center versus Joanne Collins. This is one of the exceptions on.
Good afternoon, Your Honor.
Yeah. Good over, low. Let's talk about the holiday visitation stuff first, okay? Mr. Bertram says that you didn't take exception to that.
Judge, I don't take exception to the standard holiday schedule, but in looking at the DRC's recommendations, it looks like that he was doing a phase-in visitation schedule. So there would be no overnights until after January the 15th. So I don't think we've got Christmas hashed out as far as times and things.
Let's hash it out now.
Well, and I had offered Mr. Bertram some different times, both on Christmas Eve and Christmas Day for his client.
What?
Your Honor, the DRC just said follow the local rules. She didn't follow any exceptions to that. We just want what's in the standard, Christmas.
Well, the phase-in was in the situation, wasn't it?
The phase, we would be in the phase-in period, yes.
Yeah, well, let's phase in something. That's what we're gonna do. Okay, let's pick out.
Judge, we would propose that on Christmas Eve, she would take the child to Mr. Center's house at 1 p.m. Central. and they would stay to visit at least till 6 p.m. And then she would bring the child back on Christmas Day at 4 p.m. Central and let the child stay until 8 p.m. that day.
That's sufficient.
Does it have to be supervised?
It's not supervised. She didn't say supervised.
So she don't,
I can have
Christmas.
Yeah,
Yeah,
for those times.
That's fine, sir.
it's okay. Okay, now, let's go down through these other things.
The
Okay.
first one, I don't.
I've got it here, the decree should direct the parties to use the child's legal surname of Collins Center.
There's no objection.
We don't have an objection to that, Judge.
Okay, the decree should begin, the decree says child support should begin on December 1st, 2023, as opposed to August 1st, 2023. He's been paying the expenses of the child.
That's contested, Your Honor.
That is contested.
The DRC report reflects that he did pay expenses during the year, but wasn't paying monetary child support. And my client has paid expenses that she's requested. So it's either started on December the 1st or giving credit for what he's paid.
How much does he say he's paid?
It's very, sir, between clothes, gas money.
Well,
That's the thing, Judge. Our
See,
position, he's not paid expenses, and we had this hearing back the 1st of July.
how much is the child support?
We had not calculated the exact amount. I don't think that it was in with the DRC. Bear with me, maybe we did.
It is.
The amount's in there, okay. Let me make sure.
We're not disputing the amount, Your Honor, just the onset payment.
Yeah, I'm looking to see. Hold on just a second. We had the testimony. $449.31, Judge, is what the amount that was
Yes.
set.
A month?
Yes.
Yes.
Now, what's the total amount that your client claims he paid on these periodic payments?
So average, probably
It probably doesn't get it here.
300.
Okay,
And Judge, we would dispute that because him buying toys and clothes at his residence does not count for providing for this
yeah, I
child.
agree with that.
And my client has provided the transportation to and from
So what
Somerset.
I'm gonna do, if it's agreeable, you start it on September 1.
Okay, that's fine, Judge.
That gives you $450 credit that you probably aren't entitled to, but you know, you gotta be careful of what you spend and don't spend now. You just keep, you pay your child support on time. We'll start on September 1. Okay. Accepting your statement that you did pay things above that. It's not. The decree should specify equal parental time sharing at some point following a phase-in period suggested by the ed, which petitioner is not opposed. Using the word visitation is confusing and should not be utilized, giving the DRC suggestion of joint custody. I believe that's what the law is now. So the joint
Yes.
custody language should be there, and I don't think visitation.
And we're not opposed to using the word timeshare as opposed to visitation. We are opposed to the equal timeshare, Judge.
Well, or that should be the ultimate goal. That's what you're saying. That's what the goal should be, right?
Yes, the statutory presumption is that, and it
I-
basically, at the end of the phase-in period, he goes to every other weekend. There should be another, I guess it just stopped too soon. It should say that after so much of that visitation, it would go to.
Well, I would say that after a period, he comes back in front of the court for review.
That's what I would ask for, Judge.
Let's do that. That way he's got some hope doing that and, and she's got some, feeling that it'll be another review. So.
But
y'all
in
get that.
practicality too, this child is enrolled in Cumberland County, has resided his entire life in Cumberland County. He goes to school here. Mr. Center lives in Somerset on a different time zone. So the practicality of during the regular school year, that would not be possible.
Well,
And then
he might move.
and then there was also testimony in the record that was provided as far as his history of DVOs with prior significant others, issues in his visitation with his other children that he had.
Put there, put in there, you don't need to get in detail. It's so that he should conduct himself appropriately and protect the children from anything that's inappropriate. That's enough.
What delay period would you like after that? It goes to every other weekend for the review.
Well, let's take a look at about 3 months initially. in.
3 months after that?
No, from these visitations start.
Okay.
That would be, April 25th.
That's fine.
Okay, we'll come back in and see how it works between now and then. Okay. And then,
Number 4, Your Honor, I just thought was an oversight because now that he's paying monetary child support.
we hadn't paid it yet. Now he's
but
supposed
he's
to.
gonna start. And we're just saying that when he pays child
Are
support.
they gonna meet somewhere? Or you just want to trade times transport?
Well, Judge, again, this child's 5 years old. He didn't file his petition till this year, and she's bore all the expense and the cost of taking that child back and forth to ensure he got visitation. So I don't think that that aspect is unreasonable. I'm agreeable if you want to review that again in April when we start reviewing the other factors. But given that his child support has not started, we're here in December,
Yeah,
it's the end of the year.
I kind of, well, as we expand visitation, it'll go to 50-50. Let's wait till we come back in
April.
March to look at that.
We're going in back in March or April?
It was
I'm
April.
asking him April
April
25th.
25th.
Yeah.
Let's take a look at that, as far as the cost after that. If I were her, I think I'd rather meet him in Monticello somewhere than have him transport the kids all the way back and forth. I mean, you want to talk to her about that? At least if you meet in Monticello, you get the kids some fast food. Go to
My client's
McDonald's,
not opposed
Wendy's.
to it. Yeah. The new restaurant changed, if you've not eaten it yet, it's really good. Real job on the square.
No,
It was phenomenal.
Judge, she would be amenable to doing the language of the receiving parent does the transport, so she's willing that Mr. Centers could come down here to pick Christopher up, and then when it was time for her to pick the child back up for visitation, she'll drive to Somerset and pick him up.
Well, if that's what they agreed to. If I was her or him, I wouldn't want to go about the other person's house. If you meet at a neutral location in Monticello, it might hold things down at the police station or something up there,
Just some concerns, Judge, about some of his drinking habits where the proof was in the record.
Well, okay, now, he used to drink. We got that in. I'm sure he has other sins in his past. If you want to throw some of those in now, we can, but I'm concerned about him driving all the time, back and forth.
And that's why we were saying that she's willing to drive to Somerset for the pickups.
And for the
To his
return,
house.
and for the returns, what's the deal?
That he would come when it's time for his visitation to pick the child up here. And then she would come to Somerset when his visitation ended and pick the child up. But I mean, if the court wants her to meet in Monticello, we'll do whatever the court
I do it
wishes.
right. I'm more comfortable meeting in Monticello,
Okay.
just tell you the truth.
Yeah.
That,
You want to do the Monticello Walmart?
I
That's fine.
personally don't want to, but.
No.
Yeah, it's fine. Walmart's
That's
fine.
public place.
It's public. I know they
Yeah,
have
it's
cameras
public
that work,
place
so.
and everything there. And that way they don't have to get around each other's homes or anything. I kind of like that, Okay, now it goes to number 5.
I don't think there's any objection to that, Your Honor. I've just had parties be really confused about their obligations under joint custody, and I always like to include in there, they have an affirmative obligation to cooperate, and not make any unilateral changes in the child's.
I think that's.
Yeah, we don't have any
that's good.
objection to
Okay,
that,
if y'all
Judge.
can draw something up on that, and I would suggest that maybe, I know hope springs eternal, that we can start a new deal. But, and I'll tell you, a word to the wise is sufficient. I don't know, and I want you to acknowledge anything, I don't know whether you've had any appropriate videos or any of that, don't say anything. But that you're suspected of that anyway. And if I were you, I would be extra special careful about, cleansing my residence and anything that would be even suspected of being inappropriate, right? Now, they say a word to the wise is sufficient. Okay. Okay. Okay, well, thank y'all very much.
Thank you. Have excuse, John.
Absolutely. Merry Christmas to you. Merry Christmas. Yeah. Mildred Gross versus the universe.
That's a good way to describe
Yeah,
it, Judge.
this is 23 CI 0063 and 23 CI 064, which is a companion case. Is that
Yes,
correct?
yes.
And so you want an order, you want to amend your complaint twice, or you want one amended complaint?
I need to amend it on both cases, Judge.
Yeah.
To,
Are
add
they
in
just
this-
different pieces of property with different ownership, or why we have two cases here? I read them.
There's
and
two
couldn't read
cases, because this was her son associated with the property.
on one of them.
On one piece of property, yes.
Yeah, so they're two separate pieces of property.
No, only one piece of property, Judge.
Why do we have two lawsuits?
He did not have any heirs. He died without any children, which means he was not married. The property would have reverted back to his parents, so we're going down the line with her heirs.
Okay. Well, it seems like to me you could combine these two in one thing and just explain it in the pleadings, but
Okay.
if if it ever goes to trial, which it probably won't, you know, why don't you take a look? I'll allow you to amend the pleadings. Why don't you also, when you amend the pleadings, merge these two cases and you can have everything, okay?
Okay, thank you, Judge.
I'm glad you told me it was the same piece of property because I was a little confused about it. I thought they could have had another with a slightly different set of heirs, you know?
Yes.
You don't think we're going back to the moieties, do you? You ever done you know what a moiety is when nobody has the heirs and you go back to their parents' heirs and it's one moiety to each side? I had one of those. I suggest if anybody comes in your office with those, you turn them down. Okay, thank you very much. Ray versus Cowan.
So, yeah, talk to you soon.
Ray versus Cowan. We heard anything from anybody on that? Pardon?
And Judge, my client has started a new job, so his mother and the supervisors are supposed to be here and be present for that.
Okay.
And then one other housekeeping matter while we're here. It looks like we need an amended temporary order that addresses the temporary custody so we can have the DRC.
She's seen that.
I'll just give her a copy of that, Judge. Because the other one doesn't address the custody, and I think there's some confusion with the school.
That matters down. Is there a confidential matter? Those people are here for the confidential matter with those children back. Why don't you inquire if they're here for the adoption? If it is, I'll downstairs too. You have a bailiff to show, they're not here for that?
No, I've got both those adoptions and those are a party.
They are not a party?
No.
Okay, what are we doing? What do you want done?
Judge, we're here for, just to establish some temporary holiday visitation. We were requesting that the visitation with Ms. Cowan's children be moved to her parents' home in order to foster perhaps more positive interaction with her child. Right now it's at the petitioner's parents' home. And while Ms. Cowan is there visiting, she's kind of been asked to watch the petitioner's other child while she's there. She's kind of had to take on watching that, which limits her already
very limited time she gets with her
Is this other
child.
child a sibling of her children?
No, this, it's a sibling on the father's side, not the mother's side.
It's not a sibling at all then.
It's a half sibling,
Yeah.
yes.
Yeah.
And,
How old
for
is
the
that
holiday
child?
visitation, it would allow for the maternal side to also be able to visit.
Yeah, you don't have any objection.
Actually, I do, Judge, and I've provided Ms. Perigin with copies of messages because Ms. Cowan has been conducting Suboxone and marijuana sales via chat with people, and that chat is going to this particular child's iPad. And so there's some concerns about issues of drug use, and these are dated even up till this past Sunday. And I have the supervisors here. I'm not real sure where this statement is being made. We spoke,
Supervisors of what?
the supervisors of the visitation. I'm not real sure where this
I
statement
mean,
that
you're
she's,
just opening a whole nother thing here, right? Is
Judge-
that, I don't see that in any of the motions or anything. Are you suggesting she shouldn't have any visitation?
no, we had offered to extend visitation even more very liberally at the supervisor's home for Ms. Cowan, and there
So she's
was
going to the biological father's parents' home.
to his father and his stepmom's residence.
Yeah.
Because that's where she had been going
Well,
before this was
who's
filed.
selling the Suboxone? Her?
It's statements that she is,
I mean, you're saying she's selling Suboxone.
well, I mean, I've got copies
Is
of
that who you're
messages.
talking about? I don't know
Yes.
what, okay, so you say that she's a drug dealer.
I am saying that she
Okay,
is.
so you don't, but how does that affect whether visitation is at her parents' home?
Because I don't know what transactions are
Well,
occurring
I
there, because some of
guarantee
those
there-
are with her
there-
sister.
There ain't gonna be any drug transaction at her parents' home. If there is, they'll be in front of the grand jury.
And Judge, I think there's another issue that there's somebody in the residence of her parents' home that has also got pending drug charges.
Who's that?
What's the name, Jimmy Dog? Brittany Cowan. So I mean, there are some concerns about the safety of this child. And just to refresh the court's memory, this is the same individual that had charges pending still in Monroe County for another child.
Judge, she's been reunited with the other child in the Monroe County case.
She has?
Yes, it is under a supervision stipulation. She has said that the other Miss Cowan does not live in the parents' home.
You get along with the biological parents of the baby daddy, okay. Okay.
Judge, that's the person that she and her boyfriend were going and staying all night with these people before this petition was filed. So if she wasn't getting along, why was she feeling comfortable to take her
Well,
boyfriend to
they
their home?
were getting along all right then, but once this happens, they don't get along. I understand why she doesn't feel comfortable there if she's not in the same relationship with the baby daddy that she was then. It does go back to everybody else's. You need to give me some compelling reasons why on these short visitation periods that the child wouldn't be all right with her parents.
Well, Judge, if I could call Michelle Ray to explain why we have those concerns about a transaction that she did while the child was present and the supervisor was present this past Sunday at the dollar store. With these messages backing that up.
No. Judge, our rebuttal to that is Miss Cowan has not been in possession of this iPad. It's actually been at their home. And we have also got another witness here today that would like to testify to alleged pain pill use.
I'm not gonna go down, I'm not gonna be hearing any of this testimony. I mean, you got proof that she's been trafficking in Suboxone or anything else, you need to go over to the county attorney's office. The grand jury meets again next month. There are all kinds of people that don't act out in bad ways, that might have sold drugs or something in the past. If we took every child in Cumberland County that ever had any methamphetamine in the car or sold any drugs, there wouldn't be children in 50% of the homes. I haven't seen anything that would any direct danger to the child. But I'm telling you, if I hear about you having any transaction or you're on warning now, you understand what I'm saying?
Yes, sir.
If there's anybody around you in your house or anywhere else that's doing anything like that, you need to get them back out of there.
Yes, sir.
You hear me?
Yes.
Okay, what's the next issue?
Well, Judge, I guess we need to set up the time constraints
And Judge, the only other part of my motion was we wanted to perhaps add in a Wednesday or
No,
maybe.
we're not gonna add anything yet right now.
Okay.
I've already made a big concession with having those things there in our home. We're not gonna be adding any time till we see how that goes.
Okay.
Okay.
And then Judge, just asking that we go ahead and enter the order that addresses that the parties have joint custody with my client being the temporary residential custodian till we have the hearing and has the same language with visitation.
What would that affect?
Well,
I think Ms. Capps wants it to affect child support potentially.
no, Judge, I haven't filed any motion to establish temporary child support. It affects the ability for the school because the school wants some document that says that there is a custody, that custody has never been established for these parties.
They have joint custody.
And that's what I'm asking for
Well,
a
okay,
temporary order on
Well,
that.
let's just have a thing that says joint custody.
And that's what that order says, Judge.
But then you said that somebody's a primary residential that
He's the temporary primary residential custodian, which he is.
that, there's no problem with that, is there? It's temporary.
And it says pending, final ruling from this court.
Yeah, you don't have any problems.
That'd be fine
That'd be
temporarily,
good.
Judge.
Okay.
Thank you, Judge.
Okay, if y'all go back there and write something out, and let both these parties agree with it so they don't leave here without it. Okay, thank y'all. Freedom Mortgage Corporation versus Victoria M. McConnell.
Good afternoon, Your Honor. Patricia Johnson via Zoom for the plaintiff. It's our motion to dismiss the foreclosure case.
You have submitted an order, it appears.
I have.
We'll sign
Yes.
it. Thank you so much.
Thank you very much. Merry Christmas.
Merry Christmas to you.
Thank you.
Okay, motion for status quo, motion for exclusive possession of residence. Have Ms. Capps run out here just a second, please. Have Ms. Capps step out here just for a second. Oh. What, this motion for status quo and motion for exclusive possession residence in Kohler versus Kohler, is there anybody here on the other side of that?
Judge, my client was here earlier, but I told him he could go ahead and leave because she hasn't been formally served yet. I double checked with the clerk's office. So if we
Thank you
could
so
pass that to
You can go
January.
back. Thank you. Pass it to January. Okay, now did we have something on your case that needs to be brought back up?
Yeah, I believe both parties are here now, Judge.
Okay. Okay. You can start now.
Thank you, Judge. Judge, we have filed motion to transfer venue of this matter under the forum nonconvenience theory. Ms. Johnson resides in Pulaski County with the child and has.
Where do you reside?
Columbia, Dare County.
This is a Dare County case that was transferred down here to me for a conflict.
It is, but Ms. Johnson and the child have lived in Pulaski County for a lengthy period of time now.
You say that she's violated, you found kind of filing yourself that she should be held in contempt for violating a court, or what you allege your violation is?
Why do I believe that?
Yeah, how is she, just give me a short
Okay,
synopsis.
whenever the court order was first made up in 2012, 2013, I trusted her and her attorney to make it up, so they wrote it up. I was to get her 2 days during the week and every other weekend.
How's she violated?
Since August 17, 2018, I haven't seen my daughter at all. 5 years, 6 years.
Okay, what do you have to say about that?
Just wait a minute, please. Judge, she certainly has not. Since entry of that order, Mr. Sparks has been in jail. Well, this is his criminal record. I can't even tell you the number of
Well, you and I
times.
both know that if there was some reason that she should not follow the order of the court, that she should have come to the court and asked for it to be modified.
Sure, I wasn't done yet. Most of that time he was in jail. their actual order states that she'll be given sole custody, that he would receive 6 hours of timeshare on alternating weekends, and twice a week he would receive 4 hours. And then it clearly states, as agreed by the parties, over the last 4.5 years, Mr. Sparks has not once contacted her to arrange his time sharing, predominantly because he's been in jail on strangulation and wanton endangerment charges. His last stint in jail ended in October of this year. We believe a larger hearing warranted on his claim. Even in his claim, he doesn't focus on his own allegation of contempt, but arguing parental alienation, which is a criminal argument. But regardless, we do confront that.
Let me tell you what I'll suggest to you. We don't have a family court here. We use a commissioner. We're really not set up as well to deal with these things. You need to lawyer up. Let me finish what I was saying. You need to lawyer up, and I believe that you would be better served to have this transferred to Pulaski County where they got a family court and they can respond to. Now you go ahead and say what you want.
I'd spoken to Ms. Johnson before we come in here, and I told her that, you know, even though I filed, it was a custodial interference in the kidnapping statute, which is Class D felony, parental alienation, and willful contempt of court. You know, I told her we can still work this out. I just want to see my daughter. I'm fine with her being in Pulaski County. I'm fine with, as I trusted her before, you know, sign whatever. I just want to spend time with my daughter.
How old is the child?
11. And Judge, she sees both a counselor and a psychiatrist because of the anxiety of her last visit with Dad and visits prior.
Okay, that's your position, you know,
Well, I mean, she actually does see
well,
them.
that's your position if that's why she has these problems. That might be why. That's a factual determination. I understand you're an advocate and you're advocating that position. He needs to lawyer up. It'd make your job a lot easier.
Oh, absolutely. I'd like to not get those phone calls anymore.
You cannot make it through this thing without lawyering up. I'm telling you.
So,
okay, so this, I'm gonna sign a transfer to this to Pulaski Circuit Court. That'll give you some time to lawyer up and have your lawyer contact her and maybe step back away from it. You can't represent yourself in this thing because you're so too emotionally involved.
I agree.
Okay, so you submit me an order. I'll place his, or I'm not gonna rule against his motion. I'll just say it all, the motion, everything be transferred up until he gets an attorney. Now, is the child not in contact with him at all now?
Not at all, not since he left the child in a vehicle for
I don't want to
hours.
hear these allegations. I would just ask you yes or no.
He has had no contact with this
Is the
child.
child willing to talk to him over the phone for Christmas or anything?
Would she take a phone call, do you believe? When's her next appointment with the counselor? She could do a phone call from the counselor's office?
That'd be okay.
When would be her next appointment?
Why don't you check and see the next time she's at the counselor? It's safer for them to have somebody listening there when the conversation, you know what I mean?
Yes, sir.
So why don't you contact him and see if he can have some phone visitation limited while the counselor's present?
Sure, if you don't mind, I'm gonna ask him to give me a telephone number and email address, because our last phone calls didn't go well.
And may I also say, I had tried contact in 2018, I've got the a welfare check. I had that done. 2020, I saw it at a gas station. And
Well, that's beyond my
Okay.
scope right now.
Well, I tried contacting her over the years.
Okay, it's okay. You'll get an opportunity once you lawyer up to do this.
Yes,
Just
sir.
give that and they'll make arrangements for you to have a pleasant conversation. You don't need to ask the child, you know, why don't you visit me, or why are you going to a psychiatrist or any of that kind of stuff. Just say that you're thinking about it for Christmas. Do you have a Christmas present for or anything? You might make it, you know, an opportunity to leave it for someplace where she can find it. It's important that this child doesn't feel like, even if her dad's got problems, that he's abandoned her. You know what I mean? I'm just saying, as a guy that's seen these for a long time. Okay, well, thank y'all very much, and I'll enter the order, and I hope things turn around for everybody, okay?
My cell phone was in there.
Is there an email, may I have an email address?
Sorry.
Thank you. Sorry.
Is the jury coming at 2? Are they out there?
Thank you.
Okay, now what, is that the only thing we have?
Yes, Judge. I mean, you've transferred it. You'll get an order this afternoon or tomorrow.
Yeah. But I'm gonna miss you, but maybe 5 or 6 years from now, I'll see you again.
Yeah, really. You guys have a great holiday.
Okay, you too. You too, sir.
Second, I'll see you
Yeah.
right out in the hallway, okay?
May we
Oh, go ahead.
approach
I'm
you?
coming right there.
May we approach you?
Let's make sure they're on separate elevators and stuff when they leave there, okay?
You'll receive an email from me.
Your Honor, we have 3 pages written out.
Yeah.
Everybody signed it, except you. Once you sign it, I'll then type it, but I didn't want there to be any misunderstanding.
Okay, well,
so we went
go
and
ahead,
wrote it
go
out.
ahead and just type it up and make a copy of it to take with you to type it up and then I'll sign it, okay?
Thank you, Judge.
I can sign a written one as far as
We
that
got,
concerned.
we got it ready.
Okay, well, just hand it up here.
Yes, sir.
I'll just trust with you three, I'm sure that's been read 5 times.
Yes, sir.
Okay.
We have pictures, Judge.
There's 3 pages to it, Your Honor.
Okay. Now, those folks on the back row back there, what are they involved in? Is that over with now?
Ray versus Cal. They're actually discussions.
Madam Clerk, were y'all able to ascertain who was next on the list?
No, I'll handle that.
Thank you, Judge.
Okay. Okay, this is the order. We'll have it popped, okay? Now, does that finish, y'all?
Yes, sir. May I be excused? I need to
Absolutely.
go
Merry
downstairs.
Christmas to all of
Merry
you.
Christmas,
Merry
Judge.
Christmas.
I'm here for adoption. Let me downstairs.
That'll be downstairs, adoptions downstairs. As soon as I get let the jury in, and those folks on the back row are here for what?
So you're here for jury, right? You're here for jury.
What's
Well,
that?
adoption or what?
What kind of things in the county are going on with this?
Ray, it's Angie versus Holly.
What is
They're
it?
back there in discussion.
Okay, well, they'll need to, those people with them will need to wait out in the hall. They're welcome to wait out in the hall out there. They're entering into discussions back there, okay?
Judge, there's one DDO with.
Yeah. No, I don't. They can come downstairs.
They're not here. These
Okay,
ones
then
are-
let me call the DVO. DVO docket starts at 2. Have everybody come in, jurors.
Everybody come in now?
Calling Christy Nicole Lee versus Jared Wayne Stewart, DVO. No, everybody come in, yeah.
It's gonna all see who's never concerned.
Okay, we'll keep serving it, keep it in place, extend it for another 6 months. Okay, as soon as I get this jury thing started, I'll go downstairs and read the DVO. You go off the record. Yes, sir.